Good morning. Quite the week so far. Quite the week. But it's Wednesday. We're halfway through the week. Well, almost. And heading back to Massachusetts for more care and read. Hopefully, we're going to have quite a few more witnesses today. Went a little faster paced yesterday with the defense not cross-examining several witnesses. We shall see how the list goes today. I do wish we did get a copy of it. That would be good. But I don't. I have a witness list, but it doesn't tell us the order of anything. And they skip around a lot. And to be honest, I'm going to take this off. I don't like it. To be honest, you're not sure they're going to bring everybody on. They've been bouncing around a bit. Oh, yeah. According to the socials, people are in the courtroom and waiting. So hopefully. Okay. Morning, Liam. Just as I started, huh? You got to put some groceries and all the way? I decided to be on time this morning. Like, look at me, like ready. Drinking coffee. Oh, wondering what witnesses we're going to have today, whether the defense is going to cooperate. What I saw on the socials and kind of the comments I was getting in some of my messages, most people are just devastated with how bad the investigation was. Like, they're really upset with the last testimony of the Lieutenant Gallagher because of the solo cups and the bag, and thinking they could have done so much better. And well, when they come down to it, they go, that doesn't mean that, the evidence against is not there. But it does, for some, cause enough reasonable doubt that regardless what other evidence comes forward, it's always going to bug them. And I found that odd because, like, the evidence that is in question, as far as the solo cups and things like that, they didn't test the blood. There's nothing too obscure or nothing to say that it's of a lesser quality because they didn't even use any of it. For some, it's the fact that they didn't get the search warrant for 34 Fairview, although almost everyone admits there was no probable cause. But they're kind of hanging on the fact, well, they know cops that would just do it anyway. But they should have just did it anyway. And I don't understand that either. Yes, the fan is looking rather chipper today, right? It's just right in the middle of the screen, quite boldly there, couch. I mean, it's a good look for the fan. Morning, Teresa. Yeah, but they're armchair quarterbacking in hindsight. So easy to criticize when they were not there. Exactly. And now that we've got, like, in front of the jury, the weather, the actual conditions, we'll see how it goes. We'll see how it goes. You see, even though there are plenty of questionable areas in regards to the timeline and in regards to some of the evidence and witness statements that don't exactly gel together, it sounds like a normal case to me. Everything is off by a few seconds here and there. Nothing is perfect ever. We're never going to know exactly what happened. It's only like best case scenario. What makes the most sense reasonably? Well, for a guilty verdict, you got to not have doubt. Some are saying that Karen's own words are what's sealing the deal for the jury. I actually think that's quite a clever move of Hank Brennan right now to turn something that was so negative into a positive for the Commonwealth's case. If Karen wanted to be out there with her own words, saying things that weren't in the evidence and painting scenarios without testifying, well, then Hank Brennan can use it against her. He found a way, and he is. Morning, Maggie. I missed the afternoon as I had to go to the doctor's. Well, I hope everything was okay. But the afternoon was the weatherman, and they finished up with the investigator, and then the actual head of the CERT team that found did the evidence search that found the shoe and some more of the broken tail light after the police, because Massachusetts State Police took over from the local police. It was a homicide, and they had CERT team. They talked about no one being able to plant any evidence. But the defense still, tried to make headway with it about the condition of the snow and this and that. There were quite a few. There was 2 witnesses they didn't even bother to cross. Alan Jackson did go after the third leader, though. However, he was not allowing his words to be misinterpreted. But, Mr. Jackson did his best on a pushback there. And we ended up closing at around 3:30 instead of 4 o'clock, actually a half hour early. Good morning, Puff Bunnies. Good to see you. Sorry for the clicking, just leaving a quick message in the chat. Is it really, really loud? Sometimes the filter, you can't hear it, but the way I have the mic today, you might. Morning, Karen. I like that scales of justice you got there. Good morning, book lover. I do apologize for not being able to meet up the other day to talk. It just, by the time I saw it, it was kind of late. I do want to do that, and I'm not avoiding. It's just been rough during the week, Monday through Friday. It's just been crazy. I'll be honest, by the time the stream is done at 4 o'clock, the way my schedule is, because I don't sleep enough at night, I am like exhausted. I go right down for a nap. It is a great name, isn't it, Liam? Book lover. Like it fits so well. It fits so well with like every day I'm reading and stuff. It fits with the library. Yesterday the screen went green on us. And when I logged on to this news site this morning, it was green. And I was panicking. So I was trying to look at the law and crime. And law and crime must know that everybody's using their stream. Because, man, did they fill the whole bottom with, like, QR codes and all kinds of stuff for all of their, they really did a number on making it for everyone. Well, here they are.
So I'm told counsel wants to see me as the jury's coming over. Why don't you come up to sidebar?
Oh boy, here we go. So the jury's coming in and they're going to sidebar. So let me read Couch's comment. Of course, we open with the sidebar. I noticed the defense likes to imply that everyone on the scene is supposed to do every job. Like, you didn't dust for prints or take DNA. Sir, I'm the garbage collector that happened to pass by. Exactly. Oh, and Karen, congratulations. We finally have sun today, no rain. Awesome. Yes, I do, Maggie. I have it. I have it right here. It hasn't got lost yet this morning. Get my pen ready for the time. But I'm not writing down the time that she says sidebar. Once they get into court and they actually start like with the witness, I'll write that time one down. All the rest is just our beginning chatter because we're just there's the reads. Now I'm glad you get to garden today, Karen. It's gonna be a good day. It's a bit overcast here today. Oh, I am counting sidebars. Rocket Couch has already put it over in Twitch. This is number 1. And just like usual, we opened with sidebar. This is okay. I don't see Paul yet, unless that's Paul to the left of her, and I just don't see it focusing in. So yesterday we had our 22nd witness. His name was Kevin O'Hara. He was the leader of the search team, which is a special type of search for. Oh, there he is. Paul is there, sitting behind. That's Aaron. Karen went with them up to sidebar. It's quite a small courtroom when you think about it. And again, they have Paul in the second row. There's been talk that Karen Reed and her attorneys have been complaining that he gives her looks when she goes by. And she's been going by a lot more with all the sidebars now that she goes up there. You know, she used to just sit at the table and wait for them to come back and tell her. That's changed. Exactly. Karen has to be the Karen. Yep. No offense, Karen, but you know what I mean. She's in control there. And we have another person on our AV machine again today. We're getting all the different court employees here. I think yesterday there was a total of, was it 7 couch or 8? I had to go back. I think I stopped at 6, but I thought there was one more after that but they didn't come back. Because the last thing they actually did was go to sidebar. And I think that would have made it 7. 7, yeah. I'm thinking 7 with that last one there, Maggie. All of the Karens you know have gray hair and grandkids. Hey, nothing wrong with grandkids. I've got a couple of my own. Hmm. That's funny, Couch, possibly to speak to the judge's manager. I'm sure she's not pleased with the judge most of the time. Mm. Her faces have been pretty epic. She's been a little more drawn. In the last couple of days, the testimony's been so bad with her own words. She has not spoken to the press outside of court. Unusual for her. In contrast, she couldn't wait to get to the microphones outside on the days that Jen McCabe was there. It's a long one, though. Let's take a look around the socials and see if they know what's going on. It seems like Robert Alessi is the one who requested the sidebar, according to journalists who's in the courtroom. Of course, they don't hear what they're saying, but they can tell who's doing most of the talking. Okay. Nope, nothing yet. It's funny because all of the socials say, and court resumes this morning with sidebar.
You are unmuted.
Okay, so she can't get to her seat because Alessi is like moving over to talk to Mr. Jackson. Exactly, passing out all the papers, right? I'm wondering if that stack of papers has anything to do with what they needed to go over. So I guess they're bringing the jury now. I thought she said they were doing sidebar where they waited for the jury. I thought the jury would be there. But I guess they didn't call them till it was ready. She does have the little bit of the lemon face on this morning already, doesn't she, Couch? But, I would imagine it's a lot of stress. I can't imagine what it would be like to be on the pressure of being on trial for murder. It looks like Miss Schlesinger, he's joined the Commonwealth this morning. So not only Miss MacLaughlin with Adam Lally and Brennan. I think it's Schillinger. Holding the paper, fussing back and forth. It's so quiet there. No one's talking. The jury's not there yet. Like before a test, in the classroom. Everybody's a little tense. We have our law students. We have the defendant's family. We have the victim's family. When you were on jury, we would spend some time in the holding area just outside the court while they sorted some things out, or even be sent back to the juror's room if it looked like things may take a while. Yeah, they don't want milling in the hallway, exposure to everyone yet. And this is a tight courtroom. We can see. Getting a much later start today. It's definitely after 20 minutes beat yesterday's record. No Maye to bet though. We're at 23 minutes already. I'm hoping it doesn't go to 25, but it does appear that it may.
Judge, while we're waiting for the jurors, just for the record, I think Ms. Little had an opportunity to review the redacted exhibits from yesterday, and I don't think there was any objection to them.
That's correct. All right, thank you.
Nice to fill the void there, Mr. Yannetti. And here we go at 23:55 with the jury. Oh, then we have the fan while we wait for the jury to sit. Oh, can you hear that? That's coming from the feed. Is it the fan making that noise? Can you hear that? That's a terrible noise. Well, just so that you know,
Hear ye. All
it's
persons having anything
coming
to do
from the
before
feed. It's
Honorable
definitely
Beverly,
not coming
Cannone,
from me.
Justice of the Superior Court, holding in Dedham, within and for the County of Norfolk. Draw near, give your presence, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
All right, good morning again, counsel. Good morning. Good morning, jurors. I have to ask you those same three questions. Were you all able to follow the instructions and refrain from discussing this case with anyone since we left yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? No. All right, Mr. Brennan, your next witness, please.
Thank you, Your Honor. The Commonwealth calls Connor Keefe.
That would be witness number 23, considering Nicholas Guarino came 3 times, he got a number for every one. So technically 20 new witnesses, but 23 seatings for testimony.
Come on, sir, follow me. Now step up, raise your right hand. Thank you, clerk, thank you.
Raise your right hand. You solemnly swear the evidence given to the court and jury in the case now hearing should be truth, the whole truth, and nothing but the truth, so help you God? Yes.
All right, Mr. Brennan, whenever you're ready.
Thank you, Your Honor. Good morning.
Good morning, sir.
Could you please introduce yourself to the jury, spell your last name for the record?
Sure, my name is Connor Keefe. The last name is Keefe.
Mr. Keefe, where do you work?
I work for the Massachusetts State Police.
What's your position with the Massachusetts State Police?
I'm assigned to the Norfolk District Attorney's Office.
Are you a trooper?
Yes,
When did you first start beginning working as a Massachusetts State Police trooper?
2017.
Did you go to basic training?
Yes, the academy.
How long was the academy?
Approximately 6 months.
Did you have any further training after the academy?
On the job training?
Yes.
Yes, in various specialties.
What's your role at the Norfolk County District Attorney's Office?
I am assigned to the homicide unit where we investigate homicides, unattended deaths, suicides, stuff like that. And I'm also a digital forensic examiner at the District Attorney's Office.
Did you have a role in investigating this case?
Yes,
Were you a assigned investigator in this case?
I wasn't the main investigator, but I was involved, yes.
Did you deal with any of the digital forensic evidence?
Yes,
Specifically, regarding the digital forensic evidence, did you meet anybody to obtain a phone?
yes.
Who did you meet?
I met Jen McCabe and Kerry Roberts.
When you met with them, did you have to obtain anything from them?
I obtained a consent form and their cellular device.
After you received their devices, where did you bring them?
They were brought back to the forensics lab located at the Norfolk District Attorney's Office.
And what, if anything, did you do with either or both phones?
I conducted a forensic extraction on those devices.
An extraction, is that a copying an image of the phone?
Yes,
Is that different than analyzing the phone?
yes,
Were you involved in analyzing Kerry Roberts' phone?
no,
Were you involved in analyzing Jennifer McCabe's phone?
no.
Was your role limited to attaching it to grade key and doing the extraction?
That is correct.
And did you do that?
Yes,
In addition to the phone extractions, if you take us back to January 29, 2022, were you involved in going to 34 Fairview Road in Canton, Massachusetts?
yes.
Do you know about what time you went there?
Approximately 5:30.
What was your role at 34 Fairview Road that evening?
I was asked by my supervisor, Lieutenant Brian Tully, to assist in processing the scene at 34 Fairview Road in Canton, Massachusetts.
When you arrived at 34 Fairview Road, was there anybody else there?
Yes,
Who was there?
Lieutenant Tully, members of the Massachusetts State Police CERT team, the Special Emergency Response Team.
Are you part of the CERT team?
I am not.
Did you see what the CERT team was doing?
They were conducting an area search very front of the lawn and the street or road in front of 34 Fairview.
Did you have any role in that actual searching of evidence?
No, I did not.
What was your role, limited role that night?
To process any evidence that was discovered during the search.
When you say process the evidence, can you explain briefly, what does that mean?
Sure, I was had evidence bags, and if a piece of evidence or an item was found, I would place that item into the evidence bag
And why would you do that?
to secure it.
How would you become aware if there was a piece of evidence found?
The CERT team would alert the supervisor, Lieutenant Tully, or myself that there was an item or a piece of evidence, and Lieutenant Tully would then take a photograph of it, and then I would secure the piece of evidence in a bag, evidence bag.
Do you know if those photographs were time-stamped?
I believe so.
Your role was to put the evidence in the bag and return it to the evidence room?
Correct.
Did you do that?
Yes.
If I could begin, I'd like to show you on the screen a series of exhibits. If we could start with Exhibit 74, please. Trooper, do you recognize that item?
Yes,
What is it?
that is a black Nike shoe.
Did you see that item that night?
Yes,
74A, please. 74B. Thank you. Is that the same sneaker?
yes, sir.
After you were alerted to that sneaker, did you place that sneaker into an evidence bag?
Yes,
Did you bring that item with you today?
yes,
Do you have gloves?
yes, sir.
Do you want the lights on, Mr. Brennan?
Please, thank you, Your Honor. And Ms. Gilman, you can take the photo down, please. With the court's permission, I'm going to move this piece of evidence, item into evidence. Let me ask you a few questions before you open it. Could you stand and show that bag? There's red tape on it. What's that for?
To secure the bag closed.
If the bag is open, is it then retaped?
Yes,
Do you write on the outside of the bag?
yes.
Why do you do that?
To memorialize the date, time when the evidence was collected.
Could you open the bag and show us what's in it?
Yes, sir. Sorry.
With the court's permission, can he show the item?
Yes.
Trooper, is that the same item that you found that night?
Yes, sir.
If you could place it back in the bag. I'd ask this to be marked as an exhibit.
All right, any objections, Mr. Yannetti?
There is no objection.
I guess showing that he used the same shoe that they found, kind of dispelling some of the conspiracy.
Sir, you mentioned there's writing on the outside of the bag.
Yes.
What type of information do you write on the bag?
Date, time, location, who was collecting it.
The time that you write on the bag, is that the specific time the item was found, or does that represent a different time?
That could represent a different time.
And why would that be?
If you're processing multiple things at once, you're bagging things at different times, then when you seal the bag, that could be the time that is annotated on the bag.
Can the item be found before the time on that bag?
Yes,
Would you ever write a time later than when the item was found?
yes,
I'd like to move now to Exhibit 75, please. And preferably 75A, please. Do you recognize that item?
yes,
Is that one of the items you bagged that night?
yes,
And if we could turn to 76A, please. Do you recognize that item?
yes,
Is that an item that you bagged that night?
yes,
Do you have both of those items with you?
yes, sir.
Could you produce those, please? Ms. Gilman, you could take that down, please. Thank you. 570.
Yes, sir.
With the court's permission, I'd ask the trooper to open the bag and show the jury.
As long out and boring as this is, it's actually good because the Commonwealth is showing that regardless of the earlier part of the investigation having to use solo cups and bags and etc., once the CERT team got there and the Massachusetts State Police took over, there was proper procedure. Things were documented. Things were done with a regular chain of custody. It's not unusual for the defense to go over chain of custody like they did yesterday between the evidence that was found under the Canton Police Department versus what was turned over to the Massachusetts State Police and when it was at a later time and how it was held. We often hear that in quote. Like, I see why you left the gloves on. Those are pieces of tail light. Large pieces of tail light.
Sir, on those items that are stickers, did you put the stickers on them?
I did not.
Do you know where the stickers come from?
I do not.
Do you know if these items are ever sent to anybody other than your evidence locker? Are they ever removed and given to lab personnel and technicians?
Yes.
Do you know if that was done in this case?
Yes, I do.
Inside that bag, is there just two pieces or is there another piece in that bag?
There was another piece in the bag.
When you put the taillight pieces in that bag, how many pieces did you put in the bag?
I put 2.
Do you know if the other piece in the bag is a piece that broke off, or do you know how that arrived there?
I do not.
Could you just pull out that other small piece and show the jury as well? Is that smaller piece consistent with the same color as the two bigger pieces?
Yes.
Is it consistent with the same material?
Yes.
If you could put that back in the bag, please. I'd move this into evidence, please.
Okay.
Sidebar number 2. I knew that was coming. That is the Commonwealth trying to get ahead of the defense in claiming that, you know, the evidence has been altered in some way. Yeah, they will claim tampering. Absolutely, Liam. They will. And, you know, this is where a lot of the reasonable doubt comes in this case. Many say that although they have no doubt that she probably hit him, whether or not there's the evidence to actually prove that nothing else could have happened is another story. It seems like we're getting into the part of the testimony that's going to be the most difficult for the Commonwealth. Some of the glaring issues from the first trial in regards to the evidence, chain of command, allegations of tampering.
So, Mr. Brennan, I leave it to you and the witness how you do that part.
Yes. Sir, on the small chip piece, you don't know how it became chipped?
I do not.
I'd ask you to remove that chip. Like you to safely secure it, bring with you, and bag it when you leave.
Yes, sir.
And I'd like to introduce that exhibit.
So we're going to mark the little chip.
You
Ms.
would like to mark
Yannetti
it?
asked to
Okay.
mark that. Yes.
Then we're going to submit that for identification. So the small chip that I
Madam
asked you to
Clerk.
secure.
Madam Court Reporter has an envelope for that.
Thank you very much.
Exhibit 78.
Thank you.
Exhibit BB for identification.
Thank you. Trooper, we have one more bag of items to go through.
Yes.
Could I have exhibit 73, please? Sir, if you could look at Exhibit 73 on the screen, do you recognize that?
Yes.
And what is it?
A piece of clear plastic.
Is that piece of clear plastic, when you saw it, was it at ground level?
Yes,
Did you bag that item?
I did.
When you bagged that item, was there another item along with it in the same bag?
Yes.
May I approach, Your Honor?
Yes.
I'm showing you a photo. You recognize what's in it?
Yes.
What's in it?
The piece of clear plastic.
Is that the second piece in the bag, separate from the last exhibit?
Yes.
Fair and accurate depiction of how you saw it that morning?
Yes, sir.
I'd move this into evidence as an exhibit, please.
There's no objection, Mr. Yannetti?
There's no objection, no.
Exhibit 79.
With the court's permission, could we show Exhibit 79 to the jury?
Yes.
Ms. Gilman, would you be able to close? Thank you. You recognize that item, sir?
Yes.
And did you bring those two items with you, the past exhibit and this exhibit?
Yes.
Could you produce those, please? Are these different in color than the last pieces you showed?
Yes.
With the court's permission, could the trooper show these pieces?
Yes.
Thank you, trooper. I'd move these items into evidence.
No objection, Your Honor.
All right.
Exhibit 80.
Thank you.
Thank you, Trooper Keefe.
Thank you, sir.
All right, any questions, Mr. Yannetti?
Please, Your Honor, thank you.
Good morning, sir.
Good morning, sir.
Trooper Keefe, you testified that you received the cell phone of Jennifer McCabe and of Terry Roberts.
Correct.
With regard to the cell phone of Jennifer McCabe in particular, you had her sign what is called a consent form, correct?
That's correct.
What is a consent form?
It allows the trooper or law enforcement to, with the owner's consent, we are able to conduct an extraction of the device.
Okay. And on that consent form, there is a description of the item itself.
Yes.
In this case, it would have been an iPhone 11.
Yes.
And there also is an identifier with regard to a specific phone called the IMEI number.
The International Mobile Equipment Identifier.
Okay. And that would be included on the form as well because it identifies the specific iPhone 11 that Jennifer McCabe had, correct?
Correct.
The password was provided on that consent form
Yes.
and the form was signed, correct?
Yes.
By both Jennifer McCabe and by you, correct?
Yes.
And there was also a second trooper that would have signed the form as well.
That's correct.
With regard to the timing of the signing of that form, Jennifer McCabe dated it February 2nd of 2022.
Yes.
You also dated it February 2nd of 2022, correct?
Correct.
Jennifer McCabe did not list a time, but you did, correct?
I would have to look at the the consent form.
Okay, so your memory, you don't remember what time you indicated or if you indicated the time, but looking at the consent form would refresh your memory?
Yes.
May I approach, Your Honor?
Yes.
Now, I just ask you to read that silently and then look up at me when you're done, Trooper. Having reviewed that form, does that refresh your memory as to whether you indicated a date and time?
I did, yes.
And what was the date and time that you indicated?
It was February 2nd, 2022, 12:08.
And that would have been 12:08 p.m.?
Correct, 12:08 p.m.
The document that I handed you is not an original, correct?
No, it's not.
Does it appear to be a precise copy of the original, however?
Yes.
May I offer that into evidence, Your Honor, please?
Is there an objection, Mr. Brennan?
No, subject to redaction.
Okay. So don't put it up on the,
I will not.
Exhibit 81.
Now, Trooper Keefe, as of January 29th of 2022, you were colleagues in the same state police unit as Michael Proctor, correct?
I was.
At that time, was the unit called the CPAC unit or was it called Norfolk County Detectives?
I don't recall when it changed.
Okay, it's been called both, correct?
It has.
As of January 29th of 2022, there were only 10 troopers in the unit, including supervisors, correct?
I don't know.
It's a small unit, is it not?
Relatively small.
Within the CPAC or the Norfolk County Detectives, every case that comes in is assigned to one particular trooper as the lead investigator in the case, correct?
That is something that a supervisor would do, not me.
And have you been assigned as the lead investigator in other investigations?
No, not a homicide investigation. No,
You have not yet.
no.
The lead investigator is the trooper who is responsible for the case, correct?
Yes,
Michael Proctor was the lead investigator for the investigation into the death of John O'Keefe, was he not?
yes.
If somebody asked within your unit while this case was going on, whose case is it or who has that case, your answer would have been Michael Proctor, correct?
Yes,
The two of you have worked cases together in the past, correct?
a few.
You've worked on this case with Michael Proctor, correct?
Yes,
And in fact, within your work on this case, you actually partnered with him for certain assignments within the case, did you not?
you'll have to be more specific.
Sure. So for instance, on October 21 of 2022, you and Michael Proctor interviewed Sarah Levinson together, correct?
No, I don't recall that.
If I may just have a moment, Your Honor.
okay.
Okay, Trooper, you do not remember interviewing Sarah Levinson on October 21 of 2022 at 12:20 p.m. at the Norfolk DA's office. Is that your current testimony?
Yes,
Okay. If you saw a copy of that report, would that refresh your memory?
To an extent.
May I approach you on it?
Yes.
No, not at all.
I've placed a document in front of you. I would just ask you to read that silently to yourself. Look up at me when you're done. And Trooper Keefe, just so we're clear, I'm not going to ask you any questions about the specifics of what Sarah Levinson said, so you don't have to brush up on that.
I'd just like to refresh. Take a
Sure,
look, sir.
go ahead. Having reviewed that report, does that refresh your memory as to whether or not you participated in an interview of Sarah Levinson with Michael Proctor on October 21st of 2022?
Yes, I don't recall the specifics, but
So when you say yes, is it your current testimony that your memory is refreshed that you were actually there?
yes,
Okay. And the two of you would have participated in that interview together, correct?
yes,
But you did not write the report, correct?
no, I did not.
Michael Proctor wrote the report, correct?
Yes, he did.
He was the lead investigator writing the report, correct?
Yes, he wrote this report.
He chose the language to use in that report, correct?
I did not have any input on how he wrote this report.
Right. You had no input. You weren't standing over him while he was typing it, correct?
Correct.
Now, other examples of, and actually, let me take that back from you if you don't mind. May I approach, Judge?
Yes.
Thank you. You're welcome. Other examples are the reports on the videos that you, well, strike that. Let me start by saying this. You, or asking you this, you retrieved videos from both the Waterfall Bar and Grill and CF McCarthy's, did you not?
That's correct.
You and Sergeant Buchanan retrieved the videos from CF McCarthy's, correct?
Yes.
But lead detective or lead investigator Michael Proctor was the one to analyze the video and write a report on it, correct?
I would have to see that report, sir.
Sure. If I may approach?
Okay.
Oh, I'm sorry. And again, if you read that silently to yourself and look up at me when you're done. Okay, having reviewed that report, does that refresh your memory about Michael Proctor being the one to write the report on the analysis of the waterfall video?
Sir, I only obtained a copy of the surveillance video. I
Right.
did not do any analysis on the video.
That's my question. It was Michael Proctor who did the analysis, correct?
Yes.
And that, by the way, I said waterfall. Is that CF McCarthy's there, or is that waterfall?
This is CF McCarthy's.
Okay, I meant CF McCarthy's. He was the one to review that video, correct?
Yes, again, I only got a copy of the surveillance video.
Sure.
I did not do any
And
analysis.
with regard to the waterfall bar and grill, that was another circumstance where you and Sergeant Buchanan were the ones to retrieve the video, correct?
Yes.
But again, lead investigator Michael Proctor was the one to analyze the video and write the report on it, correct?
Yes, I would have to see that report as well, sir.
Now, another member of your unit was Trooper David DeChico, correct?
Yes.
Within your unit, did Trooper DeChico have a nickname for a first name?
Objection.
May we approach?
I'm sure the
Trooper, in terms
Commonwealth
of
is ready.
the troopers that were in your unit as of January 29th of 2022, which members of the unit had the least amount of time in the unit at that time?
I don't recall.
Were you one of the newer members of the unit?
As of January of 2022?
Yes.
Yes.
Trooper Michael Proctor had more experience than you did as of January 29th of 2022, correct?
He could have. He'd been on the job longer.
Okay, well, if he had been on the job longer, then certainly that means that he did have more experience, correct?
It depends.
You attended the autopsy of John O'Keefe on January 31st of
I did.
2022. And with regard to other members of your unit, you were the only one to attend that autopsy?
Yes.
That was done at the medical examiner's office
The medical examiner's office in Sandwich, Massachusetts.
in Sandwich, Mass. And it was Dr. Irene Scorti-Bello who performed the autopsy, correct?
Yes.
Had you met her prior to that day?
No.
Had you spoken to her prior to that day?
No.
Did you know before the autopsy was performed that your former colleague, lead investigator Michael Proctor, had discussed the case with Dr. Scorti-Bello without telling us what you knew of what was said?
Objection.
With regard to Dr. Scorti-Bello's knowledge of what the state police theory was of what happened, did you have to explain that, or was it your understanding she already knew what your theory was?
Objection.
Mrs. James, you can ask that differently.
What, if any, conversations did you have with Dr. Scorti-Bello about what your unit's theory was about what happened to John O'Keefe?
There was no theory.
Okay. You did not provide any theory to her, correct?
I did not provide a theory.
You learned at the autopsy from your observations that John O'Keefe had 2 black eyes and a swollen right eye, correct?
Yes.
You also learned that there was a small cut above his right eye, correct?
Yes.
And there was a small abrasion on the left side of his nose, correct?
I would have to reference the report for the exact words.
Okay. If I may have a moment. May I approach, Your Honor?
You want this one back?
Oh, please, thank you. So I've placed another document in front of you. Just take a look, read it silently to yourself, and look up at me when you're done. And I would direct your attention to the second page for the question I just asked you. Having reviewed that report, Trooper, is your memory refreshed as to whether you observed a small abrasion on the left side of John O'Keefe's nose?
Yes.
Now, was this the first autopsy that you had attended, or had you attended ones in the past?
I cannot recall.
It could have been the first one?
Most likely not.
When you're attending an autopsy as a member of the CPAC unit or the Norfolk Detectives Unit, you are expecting that the medical examiner is going to examine the body, correct?
Yes.
And you're there to witness that examination, correct?
Yes.
At the end of the examination, you are expecting that there will be a determination as to cause and manner of death, correct?
Not.
In this case, when the autopsy ended, you left the medical examiner's office, correct?
Yes.
When you left, your understanding was that the cause and manner of death was still undetermined, correct?
Objection.
You knew when you left that Dr. Scorti-Bello had seen the scratches or bites or injuries to John O'Keefe's arms, correct?
Objection.
You knew when you left that in your presence, Dr. Scorti-Bello had seen the injuries to John O'Keefe's arm.
Object to the line of question.
Sustained.
May we approach?
Okay. Jurors, feel free to stand up.
Sidebar number 4. And the only thing I would have added, Liam, while I was muted, was that I agreed with you. It had to be this line of questioning and on cross has to be with the door opened, agreed upon between Commonwealth and them, or the objections would be flying all over the place, as we just heard, as he started to get into the wounds. Good night tomorrow, kiddo. Have a good rest. Yeah, I hear you, Liam. You know, that thought passes through my mind too. Like when they always say, "May we approach, Your Honor? May we approach?" To hear her just say, "Nah, not today. Maybe later." Yeah. I know she has. The other day, she actually, Alan Jackson popped up in one of the sidebar, and she said, "Not now." she did. She did not now. Yep. She turned him down. We are at number 4 sidebar. A fan getting a good workout. I prefer the fan like in this position here, like right near the top of the wood. Like you could see it better. I don't like that one where it's up too close on the ceiling. Not enough to break up the eye. Fan critics, all of us. Fan lovers and fan critics. Yeah. They're going to try to get these differences in the wounds, in their opinions, in everywhere they can, coming forward with all the rest of the expert witnesses. It's all about, well, you know, it does look like there's broken toilet everywhere, but that can't possibly have done any of the injuries. Yeah.
Were you watching Dr. Scorti-Bello as she was conducting the autopsy?
Yes.
Did she appear to be looking at John O'Keefe's body?
Objection.
What?
What direction were her eyes facing when she was examining
Okay.
John
Oh,
O'Keefe's
excuse
body?
me.
I don't recall.
Okay. Was she looking at the ceiling, Trooper?
She was doing her job conducting the autopsy.
And in order to do
The
that,
body.
I'm sorry?
She was looking at the body, I assume.
Thank
I'm not
you.
in.
Thank you. And looking at the body, you saw her looking at the body, correct?
Yes.
And looking at the body included an arm, correct?
Yes.
And it was at the arm was not covered up during the autopsy, correct?
No.
It was open for you to see, correct?
Yes.
And you saw the injuries to John O'Keefe's arm, correct?
Yes.
You didn't see any bruising on his arm, correct?
I don't recall.
You didn't notice any obvious broken bones, did you?
I'm not a medical expert.
And it is common practice for the state police to attend autopsies when there's an undetermined death, correct?
Yes.
It is not at all common for the defense to attend an autopsy, correct?
I've never experienced that.
Right. And there was no defense attorney or defense expert at the autopsy of John O'Keefe, correct?
Not when I was there.
You were there, correct?
Yes.
And there was nothing that prevented you from giving input to the doctor as she examined the body, correct?
We don't give input. We give the facts that we know so far in the case.
Okay, well, giving the facts is giving input, is it not?
It's not input.
Okay. Did you talk to Dr. Scortibello during the autopsy?
Yes.
And you gave her information, if you don't want to call it input, correct?
Yes.
And at the end of it, you left without her ruling it a homicide, correct?
Objection.
I have nothing further.
No, none, thank you.
All right, you're all set. Trooper.
Seems that the Commonwealth is going to let that ridiculous just hang in the air there.
Jurors, this break we're going to take now.
Morning break already? Wow. Okay, sounds like morning
All
break.
right,
is
we're
coming.
going to take a break. The lawyers and I have some work that we have to do, so it's a little bit longer break than we normally take, and it's a little bit earlier, but we did get coffee for you, so we'll take a recess now for the next half hour. Maybe. I want counsel.
Whoa, did she just say a half hour? Oh my. A half hour? Are we not going to be able to hear it? Like, once the jury leaves, I definitely hope they come back up and we get to hear the arguments. At least let it be amusing for us. Dismiss the jury and let us hear what's going on. Sounds like a motion. That was such a weird cross. But because he attended the autopsy, of course, it did open up the window there to discuss it. Well, hopefully we're going to hear these arguments back and forth. I can see her. Yes. All right.
So I want to talk a little bit more about what we talked about at Sidebar. And I read the decision from Maryland, just cursory while we were waiting for the witness. And that was a March decision. And I can't stress enough that this should have been brought up before today. So I'll hear you about your concerns, Mr. Alessi. I'll hear the Commonwealth's response, then I'll go finish reading everything else you gave me. So what are your concerns about Jessica Hyde? I don't know if she's Dr. Hyde or what, but I remember she testified the last trial, so you have transcripts.
Understood, Your Honor. I first want to just get quickly the evidentiary basis. This is straightforward judicial notice. There are two separate decisions which require two separate.
One's a Massachusetts case, so that's easy enough.
Okay, so and that's a shall.
It's an SJC case, so yes.
Yes. Okay. So now to the Maryland case. So that's governed by federal, Massachusetts Rule 39A. And that is records of courts of other states or of the United States. The Act provision is the records and judicial proceedings, and of course, a court is judicial proceedings, of a court of another state or of the United States shall be competent evidence in this Commonwealth.
They don't
authenticated by
want
the attestation of
the correspondence
clerk or
coming
other
in.
officer who has charge of the records of such court under its seal. So I have with me, Your Honor, that State v. Herrera, Maryland case. I have the certified copy with me from the clerk.
All right, so we can mark that for identification.
Thank you, Your Honor. May I approach?
Yes.
He's been digging, trying to get this evidence not to be entered and not to have Jessica Hyde
Okay. Thank you.
testimony.
So, assuming Your Honor determines that the seal is the seal, it is a mandatory under the rule that it shall be competent evidence. It shall be in evidence. And to the extent the Commonwealth seeks to argue relevancy or materiality, that argument is precluded, Your Honor. In the best evidence of that preclusion is the immediate section below in Rule 39, which is notice of foreign law, which is not this, but it says there, the court shall upon request take judicial notice of the law of the United States or of any state, territory, dependency thereof, or of a foreign country, whenever it shall be material. So the drafters of this rule knew how to put in a qualification or condition when they introduced materiality in B, but they didn't do it in A.
Okay, so focus on what it is you think Jessica Hyde should be prohibited from testifying about.
Oh, Your Honor, I am not seeking to prohibit her from any testimony under this rule. What I want to do is to have it admitted in evidence, have it published, and question her on what she presented to the court in the Maryland case, what was presented, her report, because it was deemed not reliable. And that is what.
In one area, right? One specific area?
Well, you can call it.
The decision.
Right. Oh, yeah, just what's in the decision, but there's two parts to that decision, two areas. It's FLH, frequent location history.
Right.
But what the court also got at was Apple source codes, that she didn't have the Apple source code.
Nobody in the country has the Apple source codes, right?
Point exactly, Your Honor.
So what is it that, so you want to put in her report and question her
Trying to
about
discredit an
a
expert
proceeding in Maryland?
about
I
from
need to know
another
exactly
court
what you're
proceeding.
asking
If I could
me
proceed
to allow.
and give you the answer, Your Honor, I
Go
won't
ahead.
explain it. It's a very short answer.
Okay.
What I want to do is with regard to her 227 timestamp and her anticipated testimony on that, where she uses
back
a
to
tool,
227.
Celebrate, to determine and come to a conclusion about that timestamp. She is not using Apple source code to find out where that's located specifically in the phone and what it means. She is using a surrogate to do that. And I want to cross-examine her on the topic using this decision to say, in Maryland, you tried to do the same thing with regard to FLH. You tried to use a surrogate approach and make an opinion about whether that is in fact what's in the phone. She can't do it, and that means her testimony on 227 is not reliable. I'm not looking to exclude it. I'm looking to cross her on her reliability for the conclusions I anticipate she's going to make on 227.
They
So
make
if
no
she is
headway with
not
the
asked
Celebrate
about
expert.
that, then what?
Oh, if she's not asked about the 227, and I want to think about it, but I'm 99% certain I am not going to pursue that at all.
Okay, what do you say, Mr. Brennan?
This is an attempt to try to malign a witness with something that's wholly unrelated and not relevant to what she's going to testify to or the basis for her opinion. It is not a law that is admissible. It's an opinion. It wasn't even about a specific case. It was about a peer review. And so in a Daubert hearing, the court did not allow testimony on significant location. That's not the case here. Try to conflate the argument saying it has something to do with Apple 227. There is absolutely no basis for that argument. They want to say that another court rejected something about you, therefore the jury should reject you. There is no relationship between what she is going to testify as a basis and that opinion. That opinion did not say she was wrong. It said that it was not admissible under Daubert, unrelated. Nobody has the Apple source code. No expert can testify about Apple source code. It's only owned by Apple. And so using the words like surrogate is a way to try to cheapen her testimony in front of the jury. Here, number one, what he said, I really can't follow him. I don't understand, other than he's trying to draw some type of relevance and materiality. There's none. There's none. This is not a denouncement. She hasn't been found incredible. There's nothing about her methodology that has been rejected by a court. This is on significant location. And although she looked at it, that's not part of this opinion whatsoever. And so because another court didn't allow something under a Daubert, has nothing to do with this case. Nothing.
And what is it that you expect her to testify to, Mr. Brennan, regarding the 207 stamp? We did not have this issue with Mr. Whiffen, right? This was not raised with Mr. Whiffen.
Exactly.
Oh, it was. The 227 timestamp.
No, that was raised, but this
Location thing in the Apple code wasn't
what
raised.
was, problematic.
you're
in
throwing
Maryland.
out there.
The same thing that was problematic in Arrington.
That's correct, Your Honor. It wasn't raised because Mr. Whiffen has not been Daubertized with regard to.
Also, you
source
admit it
codes,
was a
and if I
Dauber
could,
hearing,
Okay.
which just makes the evidence,
Mr. Brennan,
not the
Mr.
witness.
Brennan has made a relevance argument. He keeps anticipating my cross, which he has incorrect, by saying it's not relevant. That doesn't go to the admissibility in my cross. I'm entitled to cross her on her reliability. And if I could, Your Honor, in the state Herrera decision, if Your Honor would look at page 3, please, at the bottom, the paragraph, it says, in assessing the reliability of an expert's methodology, I get to do that on cross. It's not limited to a Dauber hearing. Every expert can be crossed on their reliability of their methodology. And lastly, with regard to the Apple source code, if Your Honor would please turn to page 6, the last paragraph, it says the issue raised in this case stems from the fact that Apple's algorithms are proprietary and the expert did not have access. That's exactly the situation here and what I want to cross her on. So in conclusion, Your Honor, the fact that how she tried to get around the Apple source code, her methodology in the Herrera case, she got Daubertized on because it wasn't reliable. That's exactly what I want to cross her on, is her reliability, how she's trying to get around them in this case. It's just basic cross-examination.
You can see the plan to dehumanize somebody, Daubertized, to use a term to suggest some type of conclusion that has no basis in fact, is an attempt to just dehumanize her and limit her testimony and credibility without any basis in fact. In that case, it did not deal with the search of a tab and a suspended state in Safari. It didn't deal with the timestamp. It was an entirely different issue. By their analysis, if an expert goes into court on a motion on anything to do with data forensics, and the court says that issue is not admissible, they should be impeached when they go and talk about a totally different issue in forensic data analysis in another case. They have not shown any evidence that this issue has anything to do with her effort in the timestamp. They just used the word methodology. Her methodology was questioned in an opinion in a different court. Has nothing to do with her opinions here. What information do they have that her methodology in this analysis has been rejected by any court? What evidence do they have that the methodology used in this case is unreliable or improper? They don't have any. In fact, they called an expert themselves in the last case who tried to provide what he believed to be methodology, and they presented that. They proffered that evidence as reliable. No different on this subject. Herrera case is a totally different subject.
Your Honor, first of all, as
It
the
is.
court has noted, the first trial is the first trial. This is this trial. I wasn't at the first trial. The most important and probative aspect, Your Honor, is I don't want to have to give away my entire cross in this argument.
No one's asking you to. I'm not asking you to.
There is parts of Ms. Hyde's slide that go to location. There's a good part of her slide presentation. I don't want to depart from the 227, but the good part of her slide presentation that she's going to present is on location. It is with regard to health data steps. So there are certainly aspects directly relevant. Here's the issue with the 227 in addition. There is, for her methodology, she's claiming a certain conclusion and opinion about the 227. There is no peer review. There is no article that she can cite to support her methodology to come to the conclusion that the 227 timestamp, one, doesn't exist anymore, or two, doesn't mean that the search occurred at 227. That's what she's opined on in her reports pre-trial, and that's what I anticipate she's going to opine on when she takes the stand. I'm entitled to cross her on that. We can't be saddled. It's irrelevant what our witnesses said in another proceeding. It's what this witness is going to talk about in this matter, and I'm entitled, and my client's entitled to have me confront this witness on what she's going to testify and her methodology. So my point is, Your Honor, this decision, how do you impeach an expert? But one of the fundamental ways you do it is, and I don't mean to dehumanize her. I won't even use the term Daubertized anymore. She's been deemed unreliable. Attorneys who do experts all the time, that's the verb you use to shortcut it, but I won't use it. I have no intention to dehumanize her. What I intend to do is to impeach her on her reliability. So in conclusion, Your Honor, the Herrera case, she was deemed not reliable. That's competency. You, and any expert that's been deemed that, you get to attack that. If the Commonwealth believes the case is not relevant, if Ms. Hyde believes it's not relevant, let Ms. Hyde defend that on the stand. Let Mr. Brennan make that point on redirect. But I can't have my client's constitutional right to confront her on the very subject matter she's going to testify on by anticipating what I'm going to provide for cross. I've given it, and I respectfully submit, Your Honor, this is basic cross of an expert witness, particularly when their methodology on data forensics has been deemed not reliable by a court. And one part is the location. She has in her PowerPoint, she's going to testify.
Do you intend to introduce that, Mr. Brennan?
It's not significant locations. There are locations in the database that develop the opinion that the timestamp for 227 is not related to the search. They're conflating the issue. She has not been deemed unreliable. It is the issue of the significant locations by that court that they found insufficient. There's no opinion from a court that she's an unreliable expert. And this is how they're going to distort it. Invoking the Constitution and invoking the client's rights has nothing to do with the analysis. That is a totally separate subject, or an opinion simply wasn't let in a different court out of this jurisdiction. It wasn't this opinion. It wasn't this methodology for the opinions that she's going to offer in
Worried
this
about
case.
additional
And so if you
testimony.
look at the case, it is
in
a
regards
totally different
to
related, different
search.
related item. It's as if a reconstruction expert went into a court
Because it
and
blows
attempted to give an opinion about
census timeline.
a medical diagnosis, and the court wouldn't allow that medical
And the
diagnosis
fact
in.
that Jen McCabe would look guilty
In
of
another
of her-
court, in another jurisdiction, they would not be able to be cross-examined, that in some court, there was an opinion they offered that was deemed inadmissible, unless they were talking about the very same methodology and the very same point. This has nothing to do with her opinion whatsoever. It's just an attempt to try to endorse the defense's attempt to suggest she's not credible by hiding behind the shield of a different judge and distorting the fact that it's two different methodologies, it's two different issues.
One last word. Go ahead.
Thank you, Your Honor. He just said credibility. This isn't a credibility issue. This is a
Good, then you don't need
reliability.
to do
This
this.
is the essence of what experts do. You have to show that your methodology is reliable. It's a red herring to bring up credibility. The court opinion.
And this is the equivalent of a Superior Court opinion, right? It's not an appellate
It is,
decision.
Your Honor. It is, Your Honor. It is the equivalent. I respectfully don't think that the level of the court is at all relevant. Any court, unless you get it overturned on appeal, then this would be a different matter. But this is a valid case, and even if it wasn't, it shall be in evidence. So there's two issues here, and I think the Commonwealth is conflating that. The question first for the court is this admissible? Can it come into evidence? To me, that's a non-issue. Rule 39 says ipso facto, yes, as long as I've got a certified copy. So it is in evidence. I don't know why we're perseverating respectfully on whether I can question her on something that's going to be in evidence about her. Final point, Mr. Brennan incorrectly says that this wasn't about her. The final sentence, the decretal section on page 7 says, accordingly, defendant's motion to exclude expert testimony regarding the significant location data obtained from the forensic cell extraction is granted. She's the only expert, and her name is mentioned throughout this opinion. It's all about Ms. Hyde. And I'll conclude my last point, Your Honor, where I started, and that is Ms. Hyde's methodology with regard to her PowerPoint. You heard Mr. Brennan's answer. He is going to include, he has included in her PowerPoint locations, steps, etc. It's exactly what was at issue here. The 227 timestamp, she has no, and this will be developed further on cross, she has no peer-reviewed article to say that how she is determining that 227 timestamp should not be in the data. She has nothing to support that, just like she had nothing in this case with regard to data forensics. Final point is, if the Commonwealth believes that this is irrelevant to what Ms. Hyde did, let them come back on redirect on that. I shouldn't anticipatory have my cross-examination struck before I even get to pursue that with the witness. And I believe once I pursue it with the witness, it will become evidently clear that it's a proper basis for cross-examination.
Right, and Mr. Alessi, have you thought about if the Commonwealth does not get into the 227 timestamp, whether you think you're still entitled to do this?
Your answer, your Honor, my answer is I would be entitled, but I would say this: if they don't get into 227, I won't go after it. I won't pursue it. I won't pursue use of this opinion.
We necessarily would have to on some basis, because in order for the witness to explain to the jury her opinion that Ms. McCabe did not delete any Safari browser searches, she would have to identify the search, where it is in the databases, and how she can tell, how she knows that it wasn't deleted by a user. The same with the second part of the phone calls. But if I could avoid talking about 227, I would, but it is necessary for the basis of her opinion. There's just no way around it. And again, this is something that after a defendant expert may or may not testify, could be addressed at that point. There is no burden on the defendant. I'm not being presumptuous, although there was a offer of proof earlier on similar evidence, but not knowing the court's wisdom on whether I'll be entitled to rebuttal, I do not want to lose the opportunity to address points that were made in the opening that have absolutely no basis in fact and have not been proven in any way to this point in the case.
So I asked earlier whether the defense intended to call Mr. Green, and you believe that you do, right?
Your Honor, we have not made a decision on what data forensics expert we're going to call, but if I could just 10 seconds.
Okay, but then answer my question after your 10 seconds.
But I will. Mr.
Well, that's
Brennan can't
interesting.
have it both ways. He can't say, yes, I need to address the 227 timestamp, and then deny me the ability to cross-examine fully on this expert's methodology and to impeach her and to get at her reliability and her competence, which is a key issue of crossing an expert. Her competence has been determined in this decision. And it is her, because it was her report that was the basis for the court to not allow her to testify. They can't have it both ways. You can't say, I need to do it in direct, but no, I want to handcuff the defense on cross-examination. Now to answer your question, Your Honor, we are going to have a witness that is going to address the 227 issue.
Okay.
Whether it's Mr. Green or somebody else, we haven't determined. My point on that, Your Honor, is we shouldn't be limited in our cross-examination of the Commonwealth.
No, I'm just thinking it in terms of whether this might be appropriate for rebuttal. That's.
Yeah. And Your Honor, my point would be that's obviously going to be Your Honor's decision ultimately. But again, the Commonwealth can't have it both ways. They're the ones who are triggering this issue, and I say triggering in a legal sense. They are putting at issue the 227 timestamp with this issue, with this witness. If they weren't doing that, I wouldn't be having this discussion at all. But they're putting it at issue. I have the right, respectfully, to cross-examine on the issue that they're putting in issue, and they shouldn't get rewarded with sort of having a pre-authorization of rebuttal to deal with it. They should have to meet their burden of rebuttal depending upon when the evidence comes. But I don't believe just because we may call a witness, that should dilute my ability to cross-examine this witness on an issue they're raising. I'm not raising it.
You can see why I wish I had more notice on this, right?
Your Honor, I have no good answer for that.
So I will do what I can in the next half hour. I might need more time on this, frankly, but we'll see. She's here.
Your Honor, may I ask one quick? May I, Mr. Brennan?
I just want to know, is she here?
Yes, Your Honor.
Can she stay another day if need be?
I think she'll do what the court directs her to do. She would have to leave by Friday. She cannot be here. Well, may I approach?
Yeah, why don't you come up?
Nope. Sidebar number 5. I mean, we heard all the yelling. Why we can't hear this? I guess because privacy of the arrangements made with the expert witness, but this is all about the text message that defense wants to have the jury believe that it wasn't an open browser. The 227 timestamp is correct, and that Jen McCabe did not make the search how longs to in the snow at 227. She made it, and not when Karen Reed suggested at 6 something. And isn't it interesting? They're not sure if they're presenting green. The Celebrate testimony from Ian Whiffen kind of nailed green. In any angle he can come from, he's going to look, well, dismantled ahead of time. And the fact that they're not sure they're bringing him forward shows you that the defense knows that. Wherefore, they would rather just leave that testimony stand there. They don't want a second expert witness coming in referring to any of that in the same way. Not as good as Mambo number 5. Not exactly. If she can show the process to the juror, peer review is not needed. Well, but the defense are far superior. Their own support. They are, but they, at this point, they had their witness on the list and they got him approved, even though Hank Brennan was trying to get him discredited for some other things. I think this is retaliation. I think Alessi found a little gold mine. He's been digging to look for something. He is the one who crosses with the digital evidence all the time. But I kind of agree with the judge and with Brennan. Well, the judge doesn't know exactly at this point what she's going to do. But with Brennan, I kind of agree that if it's not relevant, it's not.
Goodbye.
Oh, boy. Oh. What was that? Oh, they're bringing the jury back in. That's what that is, I guess. I think. Okay, so sidebar number 5. We don't know. That's interesting. That's very interesting to me that they're not sure they're bringing Green in, which is why Alessi would want to discredit this witness. He's not going to be able to bring a counter witness in. I'm just checking the socials to see what anybody else has said. I will tell you that the socials did erupt when Yannetti said, "Where were the medical examiner's eyes when she was supposed to be looking at the body?" What was the guy going to say? Oh, they were in the next room? I don't. That was bizarre in a way. What evidence do they have that she wasn't looking at the? I think they're upset that she didn't go into great detail about the wounds. That's what it is. That there's not enough there for them to tear apart. They are remarking about Mr. O'Keefe's about Massachusetts State Police, the forensic extractor for the DA's office, Connor Keefe. They said that when Yannetti stood up, the temperature dropped 50 degrees in the room. He obviously does not like the defense team. His whole demeanor stiffened up. It seems that like us, they notice these little things. But, prominently, we did get evidence entered in that was found at the scene and was appropriately documented following procedures. Not going to be able to tear much of that apart. The interesting thing is, had Mr. Alessi brought this for request of a Dover hearing on Jessica Hyde, would have been more appropriate. And I think that's where the judge is leaning, that should have came up in discovery pretrial. Well, apparently he didn't know about this case. This is like a gotcha. Oh, we found this. Can we use it? Kind of thing. But we shall see. It's all about that Google search again, and they need that Google search in. They need the jury to think that Jen McCabe was starting the cover up in the house, or after being at the house of 34 Fairfield. That she is part of the cover up for whatever happened in the home, and that is why she was Googling at 227, because they were going to put the body outside. And he wants the jury to believe that this woman, who was a friend of John O'Keefe, was Googling when he would die if they left him out there while she was home in bed. Make that make sense. But reasonable doubt, right? I mean, if they can use it, and they are going to keep trying. And they have not dropped that issue, even though they knew of the Celebrite update. They knew it was going to be shown how it could possibly get the stamp that way in error. They didn't really do more. Like, they did cross-examine with him, but he was just honest about the whole thing. The whole scenario was plausible and provable. I don't know. Oh man, Couch, you missed Alessi arguing with another court's opinion for eliminating Jessica Hyde's testimony in regards to the 220, something in regards to location and her methodology of getting around an Apple source code so that she could use source location from the phone. And it was deemed as to be not peer reviewed or not applicable, and it was disallowed in another court. And he wants to use that opinion to have the judge limit the testimony or allow him to hostile cross for impeachment Jessica Hyde when she takes a stand as an expert witness, and is going to show again how that 227 search, or the search window timestamp, is what I'm going to refer to it as, because that is what happened, for the house long in the snow, that one. She's going to show how it could occur, but it was actually done at 6 o'clock, the same as with him. Oh, they don't want that in. They're still arguing. They want that doubt there so that Jen McCabe would lay the foundation for the cover-up at 2 o'clock for whatever happened in the house allegedly by the defense at 34 Fairfield. Or Fairview, rather. It just works for them if it's 227. They don't want anybody coming in and saying it didn't exist. But the most interesting thing, Couch, is that they said they're not sure if they're going to bring their expert witness up, Richard Green, who found one of the only ones out there that will still show 227 as the time of the search because of the open search bar. And so I don't understand why they're not bringing him forward, since he has the testimony that was going to show it, unless he's just not confident after Ian Whiffin's testimony, kind of dismantling several of the things he tried to prove at the last trial. Having another court be cautious with new technique and new technology, which there is no precedent, it's not surprising at all. What's surprising is this is coming up in the middle of the trial instead of a pre-trial Dober hearing on the evidence and whether it was credible for the witness. because he's trying to discredit a witness that's already been approved to come into trial without a Dauber hearing. See what I mean? And yet admits that the issue is a Dauber hearing result. Make that make sense. Nope, they did not. She seems quite annoyed and she says she needs time. And Jessica Hyde is supposed to testify this afternoon. And that's why she keeps pressing, like, well, is it going to come up? Because if it's not actually going to come up, then what are we even talking about like this, Well, because it's on one of the slides, she uses location because it's part of the extraction and it's part of the overall information for something else that she's doing. The location will be there, and Alessi is saying that means that it's all they're actually able to challenge it in cross in impeach her practically, discredit her. This case just keeps getting more and more interesting. I mean, just when you think, things have smoothed out a little bit, like something else comes up. I don't know what she's going to do with this one. Well, we get to visit with the fan again. Now, are they arguing still, or are they just bringing in the jury? Unless they're just going back and forth about her availabilities again, because remember, he wouldn't want to keep that private. This is number 5, though, right, guys? Let me see. No, yep. No, this would be number 6 now, because 5 was before. Oh, Liam, I see you want 5. And when I remember the joke about Mambo number 5. Well, it's just how much time has passed, because when they do this stuff, like, I do lose track of time here. And it's only 11:15, so I know they didn't go to lunch. I don't think they went on a break. Like, they may have taken a break. They told the jury a half an hour. But I thought that they were talking about her schedule. Like the Commonwealth was going to talk about whether she could come back or not. I'm not sure. The Commonwealth needs to get their thinking caps on to work out a way to let the jury know how cutting edge the research is and how the courts are still catching up to what all the data. Yes. I think they did a good job of showing the updated Celebrate information and how that whole thing occurred from the time in 2022 when first extracted until now with Mr. Whiffin's testimony. And Mr. Whiffin was good for both sides, actually, with that. There are things that cannot be definitively said, and the defense was actually able to use that. Constant changing of technology. The fact that other technologies would still show that timestamp. But either way, when it comes in, the jury needs to just decide if it's plausible to go with the expert witnesses that are showing how it could happen, or to stick with the defense's view. And that it happened, and it is what it is. Occam's razor. Like, it shows that she searched at that time, so she searched at that time. However, Celebrate saw it as an error, an obvious error that needed to be corrected, updated their software, and now a search like that will automatically disappear, which it did on Jen McCabe's phone. Like, you're not going to be able to discredit that. When done again, it's not there with the update to celebrate, specifically to address an issue of an open browser timestamp. I mean, that's the final of it right there. I do think it's kind of shady to impeach her on a court decision from another jurisdiction that just happened. It's not even a true impeachment; it's a Dauber hearing. It is a dismissal of that part of the evidence, but not being able to bring it forward. I wonder how much longer this is to the 30 minutes that she said the break. I think you might be right that she's just continuing the break. It's not a sidebar. So I guess we'll stick at 5. I'll tell you what, my mind is racing right now in some of the things that we saw today and how there wasn't as much pushback as I thought on the evidence for Trooper Keefe. That whole autopsy thing was rather weird. Where were her eyes? He was trying to make it like he couldn't believe, like the medical examiner didn't do a good job because they did not give enough information about the wounds on the arm, at least for the liking of the defense. I mean, where do we go from here? Nobody has the Apple source code. I mean, all experts have to do something in regards to it, right? Oh, let's see. Some people are questioning the fact that Trooper Keefe could not remember when his first autopsy was, like if that was his first autopsy or another. I'm sure like he did several like around the same time and he doesn't remember which one is first. I think that was an honest answer. But now they're saying that everybody involved with law enforcement is lying about something, even small things, like it's ridiculous. People are so judgy about I mean, how they can actually infer that, I have no idea. Sometimes I think I should not be reading the socials. It's just so frustrating. Mm. I'm wondering, Michael Proctor is on the witness list, especially on the defense side. I don't know if the Commonwealth intends to call him. What did he lie about? They're trying to say about the autopsy that obviously he would know when his first one was, but that they were he purposely said he didn't know to get at the defense, to give the defense nothing to go on, to derail them, I guess. I just think maybe he doesn't remember when the first one was. It could have been before that one or after that. Like, who knows? Like, that could have been the first one before. Like, you know. They seem to get very, very annoyed when the avenues of their shenanigans get disrupted. Yeah, I thought they were going to take a longer morning break to give her time to think about it. I think you're correct, Maggie. I think I did hear her. So she heard the arguments and she did tell the jury 30 minutes. So she's probably taking a little time. I don't envy her. She's going to have to come back with this because Jessica Hyde is scheduled to testify today, from what Hank Brennan said. And of course, you know, she's going to be annoyed that Alessi brings this up now. This all should have been before. But he says it's from an order that just happened in March, this court order of a different district about this type of testimony concerning her. I don't even know how they get that opinion into the. I think her showing her methodology would dispel it, and then he could, but then he gets the opportunity to discredit it right there and then. I mean, it's not, you know, you can actually do this, but it's normally done during the Dover hearing beforehand, and it doesn't get played out in front of like us right now when a witness is supposed to testify. It's usually, we don't even get to see that the witness is on the list anymore because it is done pre-trial, in motions, in hearings, through discovery. And it's settled well before now. So I could see the judge's dilemma. Is being rushed into a decision like this is not easy, especially when it comes to technology, which takes a lot to keep up with, even if you're in the field, let alone if you're not in the field and you just have to hear the evidence or put weight on it or try to assign credibility to it. It's very difficult. I'm sure they knew, you know, since, you know, it could be, you know, you see Karen Reed on her computer all the time. Maybe she just found it. Maybe they didn't find it until now. Although, you know, I would say based on their other shenanigans that it does look like just another tactic to derail things in the middle of everything. The more that they keep doing that, the more the jury gets the impression that something's wrong. Something's wrong with the testimony. Something's wrong with the witnesses. There's issues to discuss because something's just not right on both sides. Yeah, you know, it doesn't make any sense that they got, but you know what, when it comes to the witnesses in this case, you know, being tried out on the socials, everybody has an issue. Everybody has an issue that there's conspiracy. Like, you know, this means this one lied, this one means this one. I mean, it's almost like, you know, like I said, 7 Degrees of Kevin Bacon, that game. Like you tie everybody together. Obviously, they're in a conspiracy. They're related. They know each other. Oh my God, it happened 50 feet from. Hello. You know, they ignore solid evidence like the cell phone. Its temperature just kept going down with no movement for hours. Karen Reed's own words say when she left John O'Keefe. John O'Keefe's phone collaborates Karen Reed's own words. For him to have been inside that house, we're talking seconds for everything to happen. If you take the other evidence into it, you have to ignore physical evidence of tail lights being found near the body. Where the shoe was, which would have been where an impact would have happened, since the shoe was found more towards the road. They made a big deal yesterday, or was it the day before, about the two that testified, the girlfriend and the boyfriend of Julie Albert's brother, I believe, and or not Julie Albert, or the friend. How they didn't see anybody in the car, but they didn't see him standing either. He was either already knocked down to the ground, or he was walking along the back, obscured by the vehicle. It is at exactly the time, that whole 5, 6, 7 seconds of a window of when they're saying the impact may have allegedly happened. Here's another thing that I thought, even if she didn't actually hit him and knock him off, say he fell. What if he fell? She still knew he fell. All her other actions afterwards say the consciousness of guilt. She knew something happened and did nothing about it. At least to me. I was trying to work myself around that one yesterday. It gets very, very complicated there, Liam. I would not want to have to try to keep any of these straight as far as, forensic cell extraction and Celebrate data, digital forensics in general. So many different companies. Software updating and changing all the time. But we find this all the time with DNA evidence also in many courts, to where new technology in DNA has not even been heard in the state before. We have to go through this long process. It's going through New York right now in the List case, the Long Island serial killer, the state versus Rex Harriman. The DNA, one of the DNA processes, not both, one is new, has not ever been used in the court in New York and has to be established. And this hearing's taking weeks because they present like 1 day a week, a couple of witnesses. It's still going on. I'm still waiting to hear the results of that. We had the same thing in New Jersey with Strearmax DNA, which does composite DNA with multiple sources from very, very tiny amounts, which increases probability correctness. And that hearing went on forever. They actually brought the code, the one who devised the system or wrote the code. They brought him in, the owner of the company, from New Zealand to speak. They had quite a few experts using the material in different labs, using the technology in different labs throughout the country. Talk about it. But in New Jersey, it had not been in a court system yet. Well, that did get approved. That's coming in. It was produced as, having enough peer review and being reliable enough for what it was. So that DNA evidence that is against Paul Canero, that's the case in New Jersey. That's coming in. you know. I think it gets just as complicated with cell phone data. We talk about this all the time. These cases come down to the digital footprint we all leave these days. Our cell phones and our vehicles, everything that marks where we are and what we're doing. If you'll excuse me for a moment, I need to take a quick break. I'm going to put music on for a second, and then I will be right back. But I can't bring you with me where I got to go for a sec. There you go. I'll be right back. Okay, I have a video link I can share with you. Dr. Ju, I mean, I don't put it in as exact science, sure, with the behaviorals and analysts, but Dr. G did do something recently on Karen Reed again. So here's a video link if you want to check that out. Well, we are now an hour since Alessi started his argument at 1:13. It is now at 1:13 into the stream, not time wise. Well, it's now 2:17 into the stream. It is 11:12 a.m. Eastern Standard. About quite a while before lunch. I am hoping she comes back soon. I know she needs time, but it's ridiculous. 5 sidebars so far. You are correct, Jen. Hey, 82. Any phone, it's your shenanigans every day, Jared. Every day. Right now, we're arguing about an out-of-state court. Or actually, I think they're using the Massachusetts one in March. An expert witness by the name of Jessica Hyde in this case wants to testify in regards to cell phone data usage and explicitly in regards to the supposed 227 open browser timestamp documentation on Jennifer McCabe's phone. Hot issue in this trial back and forth. It was disproved through the Celebrate expert, Ian Whiffen, that he showed actually how it happens to the jury. He showed that Celebrate acknowledges that it's an error and that those kind of phantom timestamping should be deleted. And it is in the update, as he had shown and testified to. Jessica Hyde uses some of the same information in a presentation well, basically, it has to do with nobody having the Apple source code because she has service location on her slides as part of her presentation. And apparently during a Dauber hearing in this other court, they decided that since she didn't have the Apple source code, she couldn't use service location because of the methodology she used to do the go around wasn't actually peer reviewed or marked as a solid, uncontested methodology, whatever. The Dauber hearing denied it. So without a Dauber hearing, Alessi brings a motion to the judge because they saw Jessica Hyde was on the list today. So something that should have been addressed pre-trial during a Dauber hearing or request for motion in limine to deny the evidence, a Dauber hearing to contest the expert in general. Besides doing the normal, Rat, he just brings it up orally and tosses the case at the judge and wants her to rule on it. She needs time. I don't blame her. Commonwealth's issue is that, yes, that was an issue in that case, which doesn't occur in this case because we're not asking her to testify about service location. It appears in her slide because it's part of the extraction. It is part of what appears in the extraction from the phone. So, hey, just another day in the Karen Reed trial. If that confused you, as I was telling you, well, join the club, because even just telling you I was getting confused. It just keeps going. Definitely 5, Jean. We're going to count this one as 6, but this is obviously the extension of the long break that was supposed to only be 30 minutes ago. We're into an hour now since Alessi started the conversation. Jury was told when he started the conversation that they were on break for 30 minutes, more than an hour ago. But it's too early for lunch. It's just too much. I don't even know what to think of this one, actually. We did see some physical evidence get entered also, Jared. We saw a tail light that was found from the CERT team, not from the Canton police in the first morning. But later, when they gridded off and did this after the snow, did the actual search, where they found his shoe and tail light remnants and stuff by digging around. That testimony, it also came out that there was no, they did not find any drag marks or footprints of anyone coming back and forth from the house from any direction. It does appear that the body was snowed over. There's some contention based on the meteorologist yesterday, the weatherman, about how much snow was under his body. Alessi went through this whole big calculation to kind of prove by like point whatever's the measurement under the body, that the body had to have been put there later than they said. But actually, when you look at it, the witness's testimony in regards to the very little amount of snow that fell in that first hour, it all kind of like coincides. It was so minute, this calculation difference that he did in a roundabout kind of way. He even confused the witness a little bit. I mean, I knew what he was trying to get at, you know. Both, oh, here they are.
Enter your participant. Please enter the pass.
If they come back just to go to sidebar,
You have joined the meeting as an attendee and will be muted throughout the meeting.
Oh boy, here we go.
The host would like you to unmute your microphone. You can.
All right. I appreciate the time. I appreciate people's patience. So in reviewing the rules, I look at Rule 2. So Mass Rule of Criminal Procedure, Rule 2, purpose and construction. And so upon reflection and consideration, it says these rules are intended to provide for the just determination of every criminal proceeding. They shall be construed to secure simplicity in procedure, fairness in administration, and the elimination of expense and delay. Also looking to Commonwealth versus Durand. I don't have the site. I know it's from 2016, 2017. A judge, Robert Kane, was the trial judge. So because none of the purposes here in Rule 2 are served by the admission of the Maryland trial judge's decision, particularly were offered without notice to the court previously, I'm excluding that decision. Your rights are saved, Mr. Alessi. We've got that decision marked for identification, and you certainly are free to cross-examine Ms. Hyde regarding her methodology. So that's my decision. So bring the jurors in, please.
Jessica Hyde's coming in, and do your list.
You are unmuted.
Well,
Christy, do you want this under that?
This is definitely going to be an appeal issue. Basically, because she sealed it using, you know, judge's discretion, that this is a waste of the court's time and will just make things overcomplicated for the jury without an actual issue there. Like, yes, it's true that that opinion in another court removed the testimony, the evidence, or the expert witness testimony in some areas for this witness. Well, she's saying they don't pertain to what the Commonwealth will be presenting or the witness will be presenting, but if anything comes up, he can just cross her like usual. Well, they're not excluding it. They did want her completely tossed. They did want, if not tossed, they want to be able to discredit her in front of the jury. But they're going to have to try a different way. I like how she got that dig in there about, and when you're bringing it to me.
Put it back in session, you may be seated.
Jurors, I appreciate your patience. So your next witness, Mr. Brennan.
The Commonwealth calls Jessica Hyde.
Let the fireworks begin. I like a pre-lunch firework. It's always nice.
And follow me, please. Thank you, clerk, and raise your right hand, please.
You solemnly swear the evidence given to the court and jury in the case now and here, the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Good morning.
Good morning. Good morning, Your Honor.
All right, Mr. Brennan, whenever you're ready.
Thank you. Good afternoon.
Good afternoon.
Could you please introduce yourself to the jury and spell your last name for the record?
My name is Jessica Hyde, Jessica, space Hyde.
What do you do for a living?
I'm a digital forensics examiner. I'm also an an adjunct professor at George Mason University, where I teach mobile device forensics in the graduate program. I also own a digital forensics company that does training, services, and research.
In addition to teaching at Georgetown University, do you teach in other ways?
Correction, I teach at George Mason University,
I'm
not
sorry.
Georgetown. But thank you. I also teach, my company writes and develops training courses. I teach a mobile forensic analysis course and a data structures course there to law enforcement, civilians, et cetera.
Do you engage in any other type of academics or research?
I do. I do other research as part of some volunteer activities I do in the digital forensics field. So I'm the chair of DFIR Review, which is a body that reviews practitioner-created research so that it can go through peer review. I often do reviews as a member of a reviewer for Forensic Science International Digital Investigations Journal, which I was a previous associate editor of.
What does peer
Oh, I'm so sorry.
What does peer review mean?
Peer review means that when a study is done or a research paper is done on a topic, that an assessment is done of it. There are three types of assessments that can be done. One is a methodological assessment, where you read through the methodology of the academic or practitioner-created paper and state if it is acceptable or not. The second is you conduct your own testing using the same methodology to conduct a peer review with your own generated data sets. And the third is if the original author has shared their data sets, reviewing their data sets and checking that against their work.
Has any of your work been peer reviewed in the past?
I've had 2 peer-reviewed journals. I've had an article that was peer-reviewed and published in Forensic Science International Digital Investigations regarding the standardization of file classification of recovered items. The layman's term of that would be talking about what deleted means. And then I have another paper that's been accepted that I was a co-author on in terms of timelines and correlations of forensic evidence.
You mentioned you work in forensic data analysis. Generally, what does that mean?
It means that I look at evidence of digital forensics devices, be them mobile phones, computers, Internet of Things devices, and do analysis to provide meaning and context to the data that's recovered from them, as well as performing data recovery of those same computer-related devices.
Did you have any specific education or training to learn about forensic data?
Absolutely. I have professional training both from courses I've taken, as well as I have a master's in digital forensics from George Mason University. a master's degree in that. I've taken multiple courses, advanced mobile analysis, iOS forensics courses from SANS, computer forensics courses from SANS. I have multiple certifications. I hold the GIAC GCFE, which is the GIAC Certified Forensics Examiner. I also hold the NWC 3CFE, which is a Certified Forensics Examiner.
Do you, through your company, teach other forensic examiners how to study forensic data?
Correct. I teach government agencies, both federal and state and local, how to do digital forensic analysis, as well as private sector digital forensics examiners.
How do you teach private digital forensic examiners? What's the method?
I've developed an online virtual course that we teach virtual live, so I'm always there when I'm teaching, but I also have a team of instructors. So for example, the mobile forensic analysis course that I developed right now this week is being taught to a police department in Texas right this moment.
Forensic data analysis seems like a broad field. Is there certain parts that you focus in?
I personally specialize in mobile phones and Internet of Things devices.
I want you to just give us some very basic, very general and brief background. When you're looking at a forensic device and you're analyzing it, do you rely on any tools?
That is a really interesting question. Reliance on tools is not precisely what we do. We utilize tools to extract data from a device, and then we utilize a variety of tools to attempt to parse results from those devices. But the forensics examiner has to take the additional step to both understand, validate, and provide meaning to those results.
Is there any shortcomings or dangers in simply relying on a forensic tool for a result or an opinion?
There is absolutely a danger in just relying on parsed results. When an algorithm is used to determine what data is stored as, it doesn't tell you what that data means, and that's where you need a forensics examiner. Tools don't necessarily understand how the data got there and what causes the data to exist, and that takes deeper and further human analysis, as well as, you know, if you think about it, if on your phone you can go to the Google Play Store or the App Store, and you can actually download millions of apps. There's like 6 million apps between the two stores. Digital forensics tools maybe support generously 1,000 applications. So in order to be able to parse and understand the data from applications that the tools don't know how to support, you need a forensics examiner who knows how to dig into that data, conduct testing, and determine the meaning of the data.
Were you asked by the Norfolk County District Attorney's Office to look at and analyze a phone that was related to a person by the name of Jennifer McCabe?
Yes, with a very, very specific scope to a specific date range.
Were you asked during that scope and date range to analyze it and provide an opinion about whether there were any user-initiated deletions of any web searches or Safari-type searches?
Yes, I was asked to look for deletions of Safari searches within the scope of the time frame that was dictated by the purpose of the exam.
Were you asked to look at the phone device and determine whether or not there were any user-initiated deletions of phone calls on the device?
Yes, I was asked to look for deletions of phone calls in that same date range.
And did you do both of those tasks?
Yes, that's correct.
Did you ultimately have opinions on both of those issues?
I do have opinions on both of those issues. That's correct.
And in engaging in the efforts to answer those two questions, did you necessarily have to review and analyze a web history that included searches on January 29th, 2022 at 2:27 a.m.?
I did analyze web searches that occurred at 2:29 a.m. in local time here in Norfolk on January 29th, 2022 from the device I was provided, yes. Not the device, the forensic image, for clarity.
So before we get to the two opinions that you were asked to consider or what your opinions were after analyzing the data, I want to begin by giving the background and having you share with us your analysis and your observations and opinions about the search on Safari relative to this 2/27 timeframe. Before we begin that, let me just ask you one question. Did you do anything to ensure the integrity of the data that you were looking at?
Upon receiving the forensic image, the first thing I did was I did what's called a hash of the image. So a hash is an algorithmic representation of a file. So a forensic image, all the data from the phone, it comes in one file that can then be extracted and have the rest of the data. That singular file that's received, there's actually 3, but focusing on the one that has all of the data, that archive file, you can run what's called a hash algorithm against it. There's actually multiple hash algorithms, and I hashed it, and then I validated that hash to the document that was provided along with the image file that contained the hashes that were contained in. Those hash values matched. Now, just for clarity, if you change one bit in a file, it will not have the same hash. So the hash provides integrity, and having used both hashes, which are available in that report, and ran 2 different algorithms, they both matched. Additionally, I reviewed the PDF that was received for signs of alteration. The PDF that comes with a Gray Key report is not signed by Adobe Acrobat. However, I was able to take that PDF and then examine it just like I would a phone. So I'm using the same techniques on the phone. Using a tool called EXIF tool, I was able to learn a lot about the creation of that particular PDF. And what I was able to learn about it was that it was created by, it's labeled it as being produced by Grayshift using a particular code-based application to create the PDF called PYF PDF, standing for Python Framework PDF. It is on, it's a program that you can download, and developers who create tools like Magnet Forensics, who owns the Gray Key, utilize that script, which is why it says it's produced by it, to create the actual PDF. That's what the evidence there in the data tells me. It also contains a time of when that is created, and that time was February 2nd, 2022 at global UTC, that's the global constant time, think what's in the UK, at 22:49, which local time would be 5:49 p.m. So that says that it was created approximately 2 hours and 45 minutes after the document said the image started, and it correlated with the document information. So that provided some level of certainty that that document was factual. And on top of that, I further opened the file of that PDF in what's called a hex editor, which lets me see like every byte, every 1 and 0. And from doing that, I looked for tag markers that are made sometimes in some modifications of PDFs called XMPs, which is Adobe's format of markup. And I did not find any evidence of those tags.
When you're trying to determine whether there's integrity in the data, are you able to tell whether or not there's been any alterations or tampering before the item is put on the Gray Key machine to make the extraction?
That would be when you're talking about if the physical device had been manipulated, is that correct?
Yes.
I cannot tell if the physical device has been manipulated prior to it being imaged. I can only validate if the image was correct. In theory, all of the data of anything that you did on that device would still show in the evidence of device logs and whatever locations that were touched or communicated with. But at that point, it's the same as any user interacting with the device itself.
After the phone's extracted or at the time it's extracted, does it have the history of the device on that extraction?
Could you rephrase?
Yes. At the time the phone is extracted and the copy is made in the PDF and the digital copy, does the digital copy and the PDF contain the history of searches and calls and other items on that phone?
The forensic image itself contains a variety of different artifacts or traces that are left behind by activities that a user does on a phone. Yes.
You use the term artifact. What does that mean in a basic sense?
An artifact is any type of evidence that is left behind on your phone of an action. So, for example, if you receive a call, there are multiple places in the phone that show that a call was received. That can be in the call log, that could be in a notification, that could be in a unified log that tracks the activity that the phone's doing. There's multiple locations, and each one of those residue of the fact that the call came in, that's what I would refer to as an artifact. So you could have an artifact not just about a call, about a web search, about taking a photo. Any action you take on your phone may create an artifact.
Before we get into those two questions about any alleged deletions from Safari, a Google search or an internet search, and any alleged deletions of phone calls, I want to start with your explanation or your sharing how the timestamp works relative to that search beginning at 2:27 a.m. on January 29th, 2022.
So for clarity, there's more than one search that happens actually at 2:27. There is some activity that's looking at, and I don't want to mispronounce the name of the town. I'll try Hockomock Sports, looking at activities for the sporting events at that school system, I assume, or county location. There is a timestamp for the search "Ha's long to die in cold." However, that timestamp isn't about active searches. It's about the time that a tab was either opened or moved to the background. So "Ha's long to die in cold" is the most current search in the tab that you opened at that was opened at 2:27. So if you're using your phone and you go to your browser, you have some choices. You can just open an existing tab, or you can open a new tab. A new tab was opened at 2:27 a.m. and that search was done there. Another tab, actually at 2:27, was moved to the background, and its last search at the time it was moved to the background was for, I believe it's Raining Men, the YouTube video. So those two searches both exist as what's called browser state searches, but that browser state isn't about the time that it was searched. It's about the time that the browser tab that you opened either went to the background, or if it's never been moved to the background, the current search. So the time in the instance of the "It's Raining Men" video is the time that that video was moved to the background and the new tab took over as the tab that's active. And that tab, the last search done in that tab is "Ha's long to die in the cold," because that database holds the current search. It constantly gets updated, and the time that the tab was either opened if it's the first time it's opened, or moved to the background if it's an existing tab.
Did you put together an exhibit that would help explain some of the different databases?
I did put it together an exhibit that would show that.
May I approach?
Yes.
Handing you a piece of paper. Do you recognize that?
I do. This is table 1 from the first report I created on this case on the phone that I was told was for Jen McCabe.
Is that the exhibit that will help you explain?
It will.
And move this to evidence.
Who are you approaching? Or have that good objective, you want?
Okay, come on now.
Okay, is that number 6 or number 7? I do believe 5 to date when, yep, this is number 6. Well, we knew it was coming, didn't we? Of course it's coming. You know, she's starting to talk about the presentation. Alessi wants to contest, and of course, even though she's given her decision, and they don't want to wait till cross-exam, they're pulling it up. They don't want this display. She did a very good job explaining it to the jury in simple terms. And I think that their fear is that once the visual gets added, it's a done deal. Yeah, it's 6. Yeah. And I will take your bid on that rocket couch. I'm going to go for 11 by the end of the day, but it looks like I'm definitely going to lose already. But I'll stick with what I wrote. Yeah, the Raining Men video did it. Yes. She talked about that in her testimony, about how they were talking about it at around the table when they were drinking at the party, the after party. Oh, I know you were meaning the number. Oh, objections? Oh, I thought we were talking sidebars. Because this objection went to a sidebar. So that's why I said 6. 6 sidebars. Objections? Oh my God. Like, oh gosh, if we're going to do objections during this testimony alone, oh my. Oh, this is going to be rough. It's going to be back and forth. Boy. It could be like a badminton match. Couch. It's going to go back and forth. Objection, objection. It could be. Oh my. Unless it gets resolved now with sidebar, which I don't. I'm sure Alessi is not very happy with having his oral argument dismissed and not being able to enter into evidence that case. She preserved it for the record, though. They can come up in appeal. You did it well. You have to forgive me. I'm feeling a little bit off today. I think I'm coming down with something. You can probably hear it in my voice. I'm feeling quite congested and a little bit woozy. Will we get up to 11 sidebars in the morning? Could be. Could be. We got an hour. If they go to lunch at 1, we got an hour 15 left. We could easily be at 11. Couch, anything's possible, in Turtle, anything's possible. I think you're on to something there, Turtle. It could be 11 before we even leave for the morning. I would hope not. The sun is finally out here today. It was cloudy this morning, but it seems to have cleared up nicely from what I can see out my window. The fan is still as perky as it was this morning. I don't know how it holds it up. Oh, are we back? We're back. Well, there we go.
Before we look at any chalk, I want you to explain the entire basis for that chalk and your ultimate opinions that are reflected in the chalk. So let's start from the beginning.
May I look at my copy of the chart or no?
Why don't I just ask you?
See if you can answer the questions and if you can, let us know.
Yes, Your Honor.
When you looked at the phone to analyze it, were you trying to determine when a particular search was made, specifically the search, how long to die in cold?
Correct. I was looking for 2 searches, both how long to die in CIKD and how long to die in cold.
So as a forensic examiner, how do you begin the process to try to identify and determine when that search is actually made?
So the first thing we would want to identify is what application was being used at the time to make the search. So looking at that date time stamped, it was able to, on that date, be able to determine that Safari was the application that was being used as the Google browser. And then you would begin looking at the artifacts for Safari, both those that are parsed by the forensics tools, but then further looking into the data structures that hold that data itself, and then ultimately conducting testing to determine why a certain artifact exists.
So you mentioned the beginning step is the forensic tool or tools. Did you use forensic tools to get information or parse any data regarding this potential search at 227?
Yes, I use multiple forensics tools.
Can you share with us the multiple forensic tools that you used?
Absolutely. I used Celebrate Physical Analyzer. I used Magnet Axiom. I used just the tools I used at first. I used iLeap. There are further tools I used later, but those were the three that I started with.
What tools did you use later?
Later, I used specifically, I've used Sanderson's Forensics Toolkit, the forensics browser in Sanderson's Forensics Toolkit, which helps exploit SQLite databases. And then I further reviewed in a tool called Rabbit Hole.
To begin with, Celebrate, is that a tool that you're familiar with?
Yes.
Is it a commonly used tool in the industry?
Yes, commonly used mobile forensics tool.
Is it reputable?
Highly reputable.
Why did you use Celebrate?
I use Celebrate because on any mobile exam, I'm going to validate what is captured by Celebrate and Magnet Axiom because they have the most robust parsing of what is in my tool arsenal. And then I would also follow up with iLeap closely behind because iLeap has a lot of artifacts that aren't supported by either of those tools. Using a variety of tools is going to give you different coverage, and each tool has a different perspective on how they view and display data.
You said you also used Magnet Axiom.
That is correct.
Is that a leading forensic tool as well?
Yes, that is also a leading forensics tool.
Are you familiar with that company?
I'm very familiar with Magnet Forensics. I was actually their director of forensics for 5 years, then continued to consult for them for an additional 2 years under my company Hexordia, and my company continues to be a reseller of Magnet's products.
You mentioned different tools may present information a different way. Do those tools change the underlying data at all?
That's a great question. So when we're talking about the results that a tool shows, the tools maintain the integrity of that original forensic image. And that's actually something we verify as we continue through our exams to make sure that the underlying data hasn't been changed. There are some tools, I did use some other tools, I apologize. I also used Artex and Mushy. But the, I'm sorry, Artex is capital A, lowercase RT, capital E, lowercase x, and then Mushy is MUSHY. You're welcome. I'm sorry, can you repeat the question? I got this, the spelling threw me off.
I mentioned, or I asked you about using multiple tools and whether or not the use of different tools changes the actual underlying data.
So the actual underlying data is always maintained, and we do validate that. Some tools allow you to see parsed results and then allow you to dig deeper into looking at the actual files and data structures. Those would be tools like Celebrate, Physical Analyzer, and Magnet Axiom. Some tools show you the parsed results and tell you where they got them, like iLeap. It shows you the parsed results and tells you the file location, and then you would open that up in an external tool. And then some of the tools I used are not tools that parse the results, but are tools that allow me to manually look at the data structures. So they directly allow me to look at the data structures. And all of the tools I use in this instance are tools that do not change the underlying data.
Is it important or critical to go beyond the tools presentations and actually analyze the data yourself?
It is absolutely critical. Actually, in the NIST Scientific Foundation's paper from the National Institute of Science and Technology that states the foundations of digital forensic science, it states that it is the examiner's duty to not only verify and validate tool results, but also to provide meaning to forensics parsed results.
Does software update regularly?
Oh, the software updates all the time. Typically, we get an update about once a month. And to be honest, it's not enough to keep up with how many new apps are developed and how many new phones come out and how many of your applications get updates, new features, for example, maybe in Instagram or Facebook. So the tools update very, very regularly.
When you use the Celebrite tool to analyze the 227 search, did the search "How's Long to Die in the Cold" have a timestamp on it?
There are actually multiple artifacts for "How's Long to Die in Cold." Remember earlier we defined an artifact and we spoke about it was one of the types of traces. So there are multiple traces for that "How's Long to Die in Cold." Only one of them is associated with the 227 timestamp, but there are other instances of evidence of that was parsed by Celebrite.
Is there any danger for an untrained eye to rely simply on the software when looking at a search like this, "How Long to Die in the Cold," and seeing the 227 timestamp?
Absolutely. There's a really scary danger that an examiner who has not dug into the artifact and tested to see what it means may assume erroneously that 227 timestamp is the time that what is there is searched. The search in that field of that artifact is going to always be the most recent search in the tab, but that timestamp actually means either the time that tab was backgrounded or if it's the first time the tab's been opened, when it was opened. So you could erroneously implicate a search was done hours or some time period or even days before it actually occurred. Some of us leave our tabs open forever.
In your teaching, examiners and students, do you teach about this specific concern and concept?
Yes, I teach about this concern both in my mobile forensic analysis class, my mobile forensics course that I teach at George Mason University and their digital forensics master's program, and in the data structures course where we specifically learn how to analyze these databases in question.
In your experience, how common does an untrained examiner make this mistake?
I wouldn't be able to speak to how common an untrained examiner does it, but regularly my students get those questions wrong on earlier examples I give them in class to kind of indicate to them that they could easily make mistakes without understanding meaning, and I use it as a teaching aid. So teaching, 90, 100 easy students a year, I regularly see that in untrained examiners that I'm teaching in my class, but I wouldn't be able to say that across the discipline.
You mentioned that Celebrite showed the search on the report as "How's Long to Die in the Cold" with a timestamp of 227. Is it 227:40?
Yes, that's correct.
Do you know whether or not Celebrite has updated its software?
In May, Celebrate of last year, Celebrate made an update to their software actually to remove this artifact because of its ambiguity and the risk that an examiner may overstate or misstate what it is.
Is this ambiguity reflected in other types of software?
Could you rephrase, please?
Sure. For example, when you did a report in Axiom, did it have similar reflection in the report?
Objection, Your Honor.
Ask it differently.
Did you run a report regarding this time frame through Axiom software?
I did process the image through Axiom, yes.
When you did that, was it the same or a different result?
Axiom and Celebrate really show their data very, very differently. So Celebrate takes a perspective of alerting people to possible deletions by annotating either a question mark or a red X next to artifacts that come from different areas. Magnet instead marks if the artifact was parsed or carved, I feel like now I need to explain to you parsed or carved. So parsed means that the data was where it was expected to be found, and the algorithm was able to cleanly see that this is there. Carve means that it had to run that algorithm against the data structure as a whole and found it as a partial result. So it carved it out, went and found it instead of it just sitting there exactly where it was expected to be, and shows you both the results. So it'll show all of the results of, in this instance, the sessions, tab sessions, but the data browser DB, the tab state, it's going to, instead of telling you this has a red X, it'll instead say it was carved. So it's a different presentation of the same data.
So I want to talk about deletions in a little bit, but I want to get back to the 227 search.
Sure.
So when you produced or you looked at the report for Celebrate and it showed this timestamp as well as the phrase, "How's long to die in the cold," where did you look? How did you make an analysis to determine whether or not that search was actually made at 227 or another time? What was your next steps for us?
So in looking at that timestamp, the first thing I did was actually go and look at what literature exists on the artifact, if anybody had reviewed this artifact before. I also created my own data set and tested how we could get what that timestamp means. So if I make a search in a tab and then I make another search in the tab, which timestamp is it? If I make a search in a tab and then open a different tab, what changes? I also looked at the documentation in the artifact reference guide for Axiom, which does state, it describes that timestamp as the time in which the tab is backgrounded. And it gives a stipulation that in certain circumstances, the timestamp can be earlier than the search.
Did you specifically look in any databases or for artifacts in the data to help make an analysis of when this search happened?
Of when the search happened as a whole? Absolutely. So there are multiple databases that I looked at that show search information for Safari. So I looked at the plist, mobile Safari plist. I looked at the browser state database. I looked for the history database. I also looked at the Knowledge CDB. The Knowledge CDB is a little bit different. That isn't a database for Safari. It's a database for all of Apple, so it can predict your behavior. So it takes in information that Apple wants to take in, including browser history, and it saves that information so it can make predictive information. I also looked at the caches in the Safari, which is the things that Safari is trying to make quick reference to. This would include suggested terms for commonly searched items.
When a URL or a search through Safari is typed in, or if it connects, does it leave a trace in different parts of the computer or the phone?
Yeah, so when you actually do any search, you're going to leave traces. Now, it does depend if you are in private browsing or non-private browsing. So non-private browsing is what most of us use regularly. Private browsing might be what you elect to use. Well, some people would elect to use it if they're doing searches they wouldn't want their spouse to see, like maybe they're looking at porn, or maybe you're doing something secure like looking at your banking information. You may intentionally use a private browser. For Google users, this would be the equivalent of incognito in Google Chrome, and you may intentionally use that. And so the artifacts for that are more limited than the artifacts for non-private searches. So some of these artifacts only exist for non-private searches, and some exist for private searches.
And in this case, this phone, was it on non-private or private?
So specifically the two searches we're talking about, how's long to die in cold and how long to die in CIKLD, excuse my differentiation there. Both of those searches were done in non-private browsing.
So they weren't hidden?
I don't understand the question, yeah.
Was there any applications on to mask those searches?
Not to the best of my knowledge. I did not see any.
We began with the 22740 timestamp. The next recording on that tab, do you recall what time that was?
I believe the next, and I'm trying to remember the chart from memory, if that's correct. So I believe the next thing we're looking at is the 623 suggestion from Apple search terms for how long to digest food. Am I matching what you're seeing on your chart?
Well, let me ask you.
Okay.
When you saw that, do you look on the same tab or a database? Where do you find that information?
Fair. Understood. So all of those databases I was just mentioning before, we're looking at all the parsed results from all of those. And I was looking in the entirety of the scope from the time of midnight till noon. That was the time frame of my scope of all of the content that was done in the tabs for BrowserScapeDB, Cloud Tabs artifacts, History DB, Mobile Safari plist, Knowledge C, each one of those. And then I was combining them to timeline out the activity.
At 62351, did you look into how long TIDIE in CIKD?
So that would be the next thing that we see after the Apple suggested term of how long to digest food. That's the next thing we see an entry of that. There's two immediately next to each other. I don't remember the precision on the seconds of which one's first off the top of my head, but one is in Knowledge C and one is in the Mobile Safari plist.
Can they appear in different rooms in the data bank in different places, the same search?
Searches appear in many different places. They can leave traces, such as that Knowledge CDB. I love that Apple calls that knowledge. It's like what it's trying to learn. So the Knowledge CDB, what Apple's trying to learn about you, as well as in that Mobile Safari plist, as well as at the moment of that search, which I don't have the device in that moment, but just so there's an understanding, that open tab, the URL would have been updated, or URL is the website, would have been updated to that search at that moment. Had we imaged it at that moment, it would have been how long to die in CIKD.
And finally, at 62447, did you identify any artifacts with that search that appears with the timestamp of 22740? Did you find the same?
Correct. At 624, we have two timestamps in the same two locations for how long to die in cold. The Knowledge C and the Mobile Safari plist.
So based on your analysis in that issue, did you come to an opinion whether or not the phrase "how's long to die in cold" was actually searched at 2:27 a.m. on January 29, 2022?
There are no artifacts.
So the answer is yes or no.
Can you repeat the question,
Yes.
please?
And so based on your analysis of the phone and the data using all of those softwares, did you come to an opinion whether or not the phrase "how's long to die in cold" was searched at that timestamp tab of 22740?
Yes, I came to an opinion.
And what is your opinion?
Objection, Your Honor.
Rephrase the question as to the opinion.
I'm sorry?
I'll see you at Sidebar for Mr. Alessi.
Thank you, Your Honor.
Because as knowledgeable as she is, they don't want to hear her say the words, "It was not actually searched at that time." They are doing everything they can to not have that be said. And I don't blame them, because wow, who could contest that she doesn't know her stuff? The objection is really telling. It's all about that statement, Liam, in my humble opinion. I'm not a lawyer, but hey, I see the writing on the wall. I would not want that witness to say that. And I would do what I could to keep it out. And we're on sidebar number 7, for those of you counting. Thank you, Couch. We may just make it to 11. How can they keep it out? It's her opinion. And she proved how she got there. She proved how she got there without service location or the Apple source code. So come on. Come on. Like, I vote, let it in. Let's get it off. Rip the Band-Aid off. Let's see where it goes. Come on. Like, really, what are you afraid of? Maybe these are hearsay papers. I'm glad you made that. You object to my expert opinion look? Yes, she's good, right? She's good. She's quick, too. Maybe these are the hearsay papers. I don't know. No, it's going to go on. I do want to hear her opinion, though. Is she not there to give it? She's the expert witness. Let her give her opinion. I'm sorry you don't like her opinion, defense. Well, bring your expert witness to go against it. I'd love to see a Green and Hyde matchup. That would be a slaughter. What am I saying? That would be cruel and unusual punishment. Yes, fan 2's getting some time. Fan 2 timed for house to 227. Okay, Turtle. Okay, I just can't. Like, this issue needs to be put to rest. Yep, this is fan number 2. I can tell by the condition of the ceiling. You see that like fine line over there? Oh wait, is it? Yeah, it's fan 2. There's the light. It's always hanging out with its little light. The globe. The dangle globe. It's not even a globe though. It's like a half sphere. A dome, not a globe. A dangle dome. I do need some more coffee. And I'm going to need some fresh air for lunch break. I hope you all get a good stretch and a good walk during lunch. If they can't accept her for her, what? If they can't accept her analysis, would this trial create precedent for throwing out many other lines of evidence based upon reverse engineering of Apple products? Interesting. But they can present her analysis because she showed how she got there without the Apple source. Exactly. You know what? The argument itself didn't hold up, which is why she's not allowing, that case to actually come in. It's not relevant to what she did. That particular case that he mentioned just happened in March, so I guess we'll see, Lee. We'll see how many more times it comes up. It's a Maryland case. How right you are, Couch. I said this earlier. We don't have the source code for the human body, but that doesn't mean all autopsies are invalid. Ouch. Ooh. How dare you use logic? You really don't expect the defense to logically think around this one. No, like, don't do that to them. Where will they go with the ridiculousness? Hey, Purple. Hope you had a good sleep. Thanks for the ordering. Exactly. Like, it's kind of like crazy, yeah? Yeah, that's a good point there, Couch. We don't have the source code for lots of stuff. But hey, then again, we're not defense attorneys with this client, like throwing spaghetti at the wall, seeing with sticks either. Sticking with a conspiracy theory that's been debunked. Like, seriously. What I don't understand, and this has bothered me since they said there was going to be a retrial, and a lot of the jury was talking. And I remember one of the jury interviews was that they really lost credibility, the defense, with this conspiracy thing. They didn't pay much mind to it at all. It was like Huckleberry, you know? Yeah, I know, AT2. What, you know, me and my rose-colored glasses, what can you expect? Logic in this courtroom from this attorney, really? The whole group of them. I mean, this whole conspiracy circus is, I believe in reasonable doubt, but conspiracy circus is another thing. I mean, everybody involved with the case is in on it. Yeah. This is a continual objection that we hear. This witness is making my client look guilty. You know, objection. You know what a good objection would be? Objection, my client is talking too much. Objection, my client gave too many interviews. Objection, the Commonwealth is now using her own words against me to put an exclamation point on every part of this case with her own words. Yeah. Yep. On what grounds? It's detrimental to my case. Like, you know, objection. On what grounds? I just don't want to hear it. I know, we're having our fun. And we have to entertain ourselves somehow. And we're back. Oh, she does not look happy. And she looks ready.
You've explained to us the analysis you engaged in and the process you engaged in. In forensic data analysis, is there a methodology that you use, not just looking at the printout of the programs, a methodology you use that is accepted in the industry for experts to analyze this data and come to your opinion?
Absolutely. Beyond looking at what was in the tool results, I further looked at those databases independently and conducted testing of the artifacts.
And in addition to what you did, can you share with us how and why this methodology is accepted in your practice as forensic analyst?
This methodology is accepted by NIST and by organizations like the Scientific Working Group of Digital Evidence. I'm intimately familiar as both a member of the Scientific Working Group on Digital Evidence, who helps work towards the building and development of these consensus-based documents of procedures to be followed in digital forensics analysis, and as a member of the National Institute of Science and Technology, NIST, Organizational Scientific Area Committees, OSAC, Digital Evidence Subcommittee, where we also produce guidelines such as the data set guidelines for generation of the guidelines for data set generation, which is how you do your actual testing and creation of data sets. And I was also a part of the subcommittee that drafted that. So I'm intimately familiar with the accepted policies and procedures because I am also a member of the groups that help author these, as well as review them and look and use them.
Are there articles and guidance in the industry about this particular practice of analysis?
For analysis, just for clarification, you're talking about for analysis of Safari artifacts, of mobile forensics, of browser state DB, just for clarity on the question.
Let's work our way through it. How
Sure.
about through Safari?
For Safari, there are multiple different blogs that talk about Safari, as well as I have analysis of Safari through classes I took, such as SANS 4508, which is their, 518, SANS 4518, which is the Mac and iOS analysis course, which I took.
How about the specific guidance regarding searching the different databases for artifacts?
In terms of methodology for digging into databases,
Yes.
Is that correct? There are multiple, I've taken courses throughout my master's program, courses on how to analyze digital forensics artifacts, including mobile device forensics, throughout my GIAC certifications. I've taken multiple instructor-led courses on how to do these, as well specifically that cover mobile Safari history. in mobile forensics at GMU in his master's program as part of the SANS 4518 class. And in terms of data structures, I've taken study on how to analyze databases like SQLite and PLIS are covered in those courses.
There are books on study on this methodology.
There are multiple books on digital forensics, many of which I've read, and including books specifically on analysis of SQLite databases, such as Sanderson's SQLite Forensics, which is probably the most authoritative because not only was it written by Sanderson, who makes a tool, it was tech edited by 3 renowned forensics examiners, as well as Dr. Richard Hipp, who created SQLite itself.
The methodology, the technique you use to look past the reports and actually look at the data to make your determination and arrive at your opinions. Is that methodology regularly accepted within the forensic data community?
Absolutely. Again, using the methodology from the consensus-based documents from the community, from the Scientific Working Group Digital Evidence on best practices for analysis, as well as specifically for the SQLite databases I was looking at. I do that deeply verifying and in accordance with the understandings from Sanderson's book.
Now, you share with us that you had an opinion regarding the timestamp and whether that it was applicable to the search term, how's long to die in cold.
That is correct.
Now, I want to ask you, to a reasonable degree of forensic data, scientific certainty, what is your opinion about whether the phrase how's long to die in cold was made at the time of the timestamp 2/27/40?
It's the last time Mr. Alessi on this issue, okay?
Oh, did I just hear, okay, but this is the last time you're sidebarring on this issue? I mean, they did just allow through the shenanigans her to actually prove her methodology and why it is actual credible in this field and where it's coming from. I mean, now when they say what she says, what she's going to say, how can the jury think she's anything but credible? All of this sidebarring is making the jury think they don't want this to come in. They're going to pay so much attention to what she says now. This might be having the opposite result of what they think. Or am I just like looking at the obvious here? Yeah, it is bollocks. And it's her job to keep it going. And she gets to pull a plug on it. And they're not going to like it. But they are going to get the plug pulled on it. Because now they're being ridiculous. I know that, he just can't deny her experience and expertise. It's almost like the prosecution picked a great person to do the required analysis. Exactly. They're just pissed they didn't get her first. That's exactly what it is. And they got a sub-rate expert that they're not even sure they're going to put up now after the Ian Whiffen testimony, which was the Celebrate guy who testified to all the same stuff. Now they're taking a professor of the industry in digital forensics who does this on a regular basis, teaches it to others, and has studied it extensively. And let's not forget the fact she works on the committees that set the standards. Did y'all hear that part? I did. I don't think this is going the way they thought. I think this was a Hail Mary they threw in there. And sometimes those don't work and end up going on the otherwise, Yeah, it's a nice chandelier shot there. I do believe what she's wearing is a turban. Tomcat, you asked what kind of hat that is. I don't know if you were serious enough, but it's a hair wrap of some type. Could be religious, could be fashion. Who knows? Yeah, wait till you see the fan. The fan's peeking in. You see that couch? It's like stealing some of the light's thunder right now. Our dangle dome will be getting upset with the fan any minute. Look at that fan. It won't even give the dangle dome its moment. I know they have to try everything, 82, but here's the thing. They're like a dog with a bone. Even when she says no, they just keep at it. And it's no wonder that she's losing patience with them. They're ridiculous in wasting the court's time. Zealously defending their client, as they should. I mean, they need to do what they can. But I'm sorry, you can't convince her otherwise. Once she says no, have some respect. So basically, the first sidebar, they went up there and they argued that she hadn't set the methodology down or said how credible it was, and then allowed all of that extra to come in about how more than qualified she is to make the statement that is about to come, that she does not believe, in her opinion, that search was made at 2:27. Because she believes it was made at whatever the other time is, 6 whatever. And she's going to be allowed to say it, and it's going to have credible weight with the jury now. How could it not? That's why Alessi wanted to bring in the case. Because if he let this case speak to itself, he could have discredited her before she opened her mouth. And that's not going to happen. And he's annoyed. Because she's going to look completely credible now.
All right, go right ahead, Mr. Brennan.
I'm now going to ask you for your first opinion.
Yay.
So you shared that you have an opinion about whether that timestamp 2:27:40 was, whether or not that was the time the search "How long to die in the cold" occurred. Can you tell us, to a reasonable degree of scientific certainty, your opinion about whether that search, "How long to die in the cold," occurred at 2:27:40 a.m. on January 29th, 2022?
Same objection, Your Honor.
Okay, the objections are overruled.
What I can state to a scientific degree of certainty is that search occurred at 6:24 a.m. and was the last search in the tab that had been opened at 2:27.
Bingo.
Do you have an opinion, to a degree of scientific certainty, whether there was any other searches similar to "How long to die in the cold" that evening on that tab?
Objection, Your Honor.
I'm going to allow it.
May I first inquire, you meant morning, I
I'm sorry,
assume?
that morning, yes.
Just clarifying, I did not look at evening searches. And can you repeat? I apologize. I disrupted my own train
Do
of
you have an
thought.
opinion, to a reasonable degree of scientific certainty, whether there were any other searches on that tab before the final search at 6:24:47, "How long to die in cold"?
Same objection, Your Honor.
Overruled.
Just ensuring that I have the question correct.
Please.
You're asking if what else occurred in that tab prior?
Yes.
That I cannot say with a clear degree of certainty.
Okay. Did you develop a chalk that I
I
showed you
did.
earlier?
Yes.
Like to approach?
Yes.
Here comes the roadmap that they don't
Again,
want in.
show you.
The clear
Same document, you
explanation.
Yes.
recognize it? What is it?
It is the exhibit that I created that was labeled Table 1 in the first report I had delivered.
And does that provide information that will assist us in understanding your opinion?
Yes.
I'd move subject to redaction.
Jen, you're probably right. Let's.
Your Honor, I have no issue with regard to the redaction aspect, but consistent with my prior objections, I would object to that.
Okay, I'm going to allow this into evidence. Your rights are safe. Mr.
Thank you, Your
President.
Honor. Appreciate it.
Rights preserved means on appeal.
Madam Clerk, 82? Thank you. With the court's permission, I'd like to show Exhibit 82 to the jury.
Okay,
It's a long time to get this little map in here. It's just a diagram. It just shows them how it
Could
happened.
we enlarge the first two? And we're going to need to get the right column in if we can, please.
I'll remove myself if it interferes
you
with
see it
what
from
you
there?
see.
I can. Thank you.
If you can
There we
walk
go.
us through how this exhibit
Nice
assists us
clear
in
view.
understanding your explanation and the basis for your opinion.
This exhibit shows the safari artifacts on artifacts of Google searches in Safari related to the two searches in question, How Long to Die in CILKD and How's Long to Die in Cold, that occurred on the morning of November 29th, 2022 on the device under examination.
If I look at this chart and I see in the top left, it says 2:27:40 a.m. And then under the search term, it says, How's Long to Die in Cold. How do I understand your opinion that that search didn't happen at 2:27:40?
This document is showing you the data that is the parsed result. The source of that artifact that you see in the last column is a little bit cut off, the browser state db-wall file. That database does store, how the data is stored, the search term How's Long to Die in Cold with an associated Mac Absolute Epoch timestamp that translates to 2:27 a.m. That is what is physically stored. That does not annotate the meaning of that artifact. That was determined through testing following the NIST OSAC data generation guidelines for testing.
In the second row, we see a timestamp on the left-hand column, 6:23:49. And it provides artifact, the cache record.
Mm-hmm.
What is the term, and what does that mean under the search term?
iOS Safari cache records. A cache refers to something that a computer program wants quick and easy access to. When we search on our phones, anything, a lot of times, be it in Google or in Safari, depending on what type of phone you own, it'll suggest what it thinks you're going to type in, right? So you can click it. It's trying to be helpful. In this instance, at 6:23:49, we have a cache record that indicates that Apple suggested the phrase, how long does it take to digest food?
And then under that, 6:23:51, it appears it says a recent web search, and the spelling is changed. How long, TIDIEINCIKD.
So this, in reference to these two search terms, this is the first actual search that occurs at 6:23:51 a.m. Upon beginning the typing of that phrase, Apple provided the suggested search, and the person inputting into the phone at that time continued to type out a phrase and finished it as how long, TIDINCIKD, which that is available to us in the mobile Safari plist, which tracks recent web searches. And then we'll see 6 seconds later, we get that reference in that Knowledge C database that I mentioned before. That's the next line. So that's the Knowledge C database is Apple's way of keeping knowledge about what the user's doing. It sees and holds your knowledge. It's an easy way to remember it. That's what I teach my students. So that Knowledge CDB tracks a lot of things for predictive purposes. And so 6 seconds later, it's logging that same search. So that search is being tracked in two places.
And so one search can be left as artifacts in different locations on the database?
Correct. There can be multiple traces or artifacts of the same user action in different places on a mobile device.
And if we go down to the bottom, the last column, at 6:24:47, we again see How's Long to Die in Cold. And if you look in the first column, it's the same phrase. Is that a coincidence that it appears at the bottom at 6:24:47 and also appears up at 2:27:40?
As mentioned before, through testing of the artifact for browser state DB, that artifact will hold the most recent search that happened in the tab. So it is logical that How's Long, HOS Long to Die in Cold was searched at 6:24:18, tracked in that mobile Safari plist, repeated in Knowledge C, Knowledge made its tracking in Knowledge CDB, and then that table for browser state DB, which again has the time that the tab was opened or the last time it was backgrounded, and updated just the website that was visited. So the website, that is why we get that 227 time. That's actually, as far as the data storage is, the first thing I have in there, because I want to put it in chronological time order for exhibit purposes, is actually the last thing to happen because it's the update to what's in the tab.
You offered that the how long to die in cold is the last thing to happen. Do you have an opinion to a reasonable degree of scientific certainty the time when that search was made?
Objection, Your Honor.
To a reasonable degree of certainty, I can say that How's Long to Die in Cold was searched at approximately 6:24 a.m.
Now, moving on from the 227 search, there are two other issues that you were asked to analyze. We talked about them at the beginning. Let's begin with whether or not you looked at the data and analyzed the data and came to any opinions about whether that phrase, "How's long to die in cold," was user deleted on that device.
So there's two really key elements as to if that was user deleted. If the question is, did I come to opinion? Yes.
And can you explain how you came to an opinion that we'll ultimately share with the jury?
The first line in that exhibit, the ending of that, if you remember, it said browser state.db-wall. That's important. So we'll talk about that in a second. But the first thing I want to bring up is kind of how the database works, because I didn't just look at the tool result. I extracted that database and I did a deeper analysis on it using Sanderson's tool, because that information was in that -wall file. So when a SQLite database, which is a specific way of storing, very, very common on mobile phones, actually one of the most common, when that database stores data, it has two versions. The most recent version and the version in use here uses what's called a write-ahead log. So before data is committed, it is written to a write-ahead log. I'll kind of explain it. So let's say we're in a restaurant and we're sitting at a table and we're ordering food. Our table is the table. Data is going to come to the table, and that's going to be our food. So when we order food, let's say we've got a chicken sandwich, a burger, and a pizza coming to the table. The chicken sandwich, the burger, and the pizza, the kitchen puts it in the warming area. It's the write-ahead log. The server grabs it from there. It's where data sits before it goes to the table, just like your food goes to that serving station before your server brings it to your table. Server brings it to the table. That table's got its burger, its chicken, and its pizza. Another table orders waffles and pancakes. They think it's breakfast. The waffles and pancakes are made by the kitchen. They're put on the serving area. Waitress comes over. This pizza has pepperoni. I don't eat pepperoni. Can you send it back? Waitress picks up that pepperoni and sends it back. That's a deletion. Pepperoni pizza was just removed from the table, right? We're deleting it. We're moving. We said it's not what we wanted. The waitress is removing it. She brings it back to that serving area. At that moment, that serving area has the deleted pizza, but also the waffles and pancakes that are waiting to go out to the table.
Oh,
That's how a write-ahead log works. Any that
Yay.
are happening sit in the write-ahead log
Ding, ding.
until the database is closed, and then when it's reopened, all those changes are made, both additions and deletions. So often when a phone is imaged, when we make a forensic image, the applications are still open, so we have those WAL files. When we look in our Safari browser, the database knows to read it to you in its current state. So it tells you where the waffles and pancakes are going. They're going to that table. So it shows it as if it's in the table, but it's not in the table yet. So if when we parse the data and we look at the restaurant and we don't look at the back kitchen, we would only at that time see the chicken and the burger, right? Pizza got sent back, waffles and pancakes haven't come out yet. So when we get the data, we get two files. We get the restaurant, that's the database, and we get the serving area, that's the WAL file. Just because it's in the WAL file does not mean it's deleted. It means that that record wasn't where it naturally sits yet. It could be that wall file can contain deleteds and food or data that hasn't yet been delivered to the database. So the wall file consists of both. So an assumption that the data was deleted just because it's in the wall file is actually not true. And the peer review paper I mentioned earlier that I had accepted in Forensic Science International actually has a section that explains this exact presence for SQLite databases about how we refer to that as recovered and not deleted. Actually, through that entire document, we don't use the phrase deleted. We refer to things in statement of recovery because we need to determine why it's there. So we can't say that it's deleted just because it came from the wall file. Some tools will automatically indicate to the examiner that they need to dig deeper into that. I did do further analysis by looking at the wall file. That particular item is a little bit more complex, actually exists on multiple pages because it moves as the database is being created, but all of them have the same unique identifier. So it's the same entry. It's not more than one search of Ha's long to die in cold. If there was more than one search that had occurred where it became the top element in that database, we would see that. There are, as I mentioned, other carved from the database, from the wall file elements such as the search for the YouTube video, It's Raining Men, because at some point that was the last viewed item in a tab when that tab was retired right before, also at 2:27 a.m., but a couple of seconds before the Ha's long to die in cold search. So we can see that that table is put to the rear. The newest tab that's open, which is why it's in the wall file, it's the most recent thing because it's like our waffles and pancakes, hasn't been delivered to the table yet. So it can sit in the wall file for that reason. That doesn't indicate it's deleted. The second reason is there is no user interaction in the interface to delete a tab. You can open and close a tab, and open and close tabs are tracked in that database, but you cannot delete a tab. There's no, if you were to pick up your iPhone, I know you don't have them right now, but if you were to pick up your iPhone and look, that wouldn't be a physical option you have in the interface. So it could not be deleted by a user through the interface for that most basic reason.
So a user, could they delete a tab if they wanted to?
There's no actual option to delete a tab. For your web history, you could clear the cache, for example. Most of us are familiar with clearing the cache in your web history. You might do it because you don't want your kids to see what you searched, or maybe your kids don't want you to see what they searched, so they'll delete it. But you can't delete the tab history. It's just what tabs are there. The device is tracking that.
When you looked at the software, whether it was Axiom or Celebrite, when you look just at the report, not the data itself, do either of those reports have any indication noting that that web or that Safari search is characterized as deleted?
The tools, Celebrite denotes it with a red X, which means that it is recovered. Axiom indicates that it is carved. In the same paper that I referenced earlier that I authored, there's a chart in there that shows the distinction between how different tools, some will use red X's, some will use question marks, some will list carved or parse. So every tool chooses to do that differently. That does not mean deleted. It means it needs further analysis.
Should an examiner who looks just at the reports of the software assume that if it is marked as recovered in Celebrite or carved in Axiom, should
an examiner should never assume something's deleted without doing a manual examination.
The manual examination, is that a method that's used, that's generally accepted in the forensic data field?
The NIST Science Foundation paper, as well as the dataset generation guidelines, both speak to conducting testing to verify and validate, and it states clearly that an examiner is to verify and validate findings and to determine meaning.
So given that you've used multiple tools to look at reports regarding this phrase, how long to die in cold, and have seen indications or characterizations of recovered and carved, and in addition to the fact that you actually analyzed the data, did you arrive at an opinion to a reasonable degree of scientific certainty whether or not the user any user deleted the phrase, how long to die in cold?
Yes, if it's how's long to die in cold. Sorry, trying to clarify.
Pardon me. Did you come to an opinion to a reasonable degree of scientific certainty whether any user deleted the phrase, how's long to die in cold?
Yes.
And what is your opinion?
My opinion is there was no deletion that occurred by the user because it is not something a user can delete.
Finally, I want to ask you about your analysis of the phone records on this phone attributed to Ms. McCabe. Did you go through an analysis of the phone logs and the phone records on the phone?
I analyzed the call logs and the phone logs on the device that I was given, that I was told belonged to Ms. McCabe, yes.
Would a suggestion or a claim that a user deleted irregularly a number of phone calls, would that be accurate or inaccurate in your experience?
It is inaccurate in this instance.
Can you explain to us why and how you came to that conclusion?
Yeah, this is actually really interesting because of what it appears in the forensics tools and additional artifacts that I looked at that are not parsed by the forensics tools. So the call logs, when you look at it, it appears, I don't remember if it's 8:57 or 8:59 a.m. in my mind at the moment, but approximately either 8:57 or 8:59 is the earliest phone call we see on the 29th of January. We see no call logs before, but we do see FaceTime logs before. So if an examiner, again, was making assumptions without testing or reviewing, the first assumption might be, well, things must have been deleted because there's data that exists before, but not current data. So then you have to go, how do phone logs work? And again, create test data and review. What the situation here is that there are three types of call logs on this particular phone. There's regular calls, incoming and outgoing. There are FaceTime video chats, incoming and outgoing, and FaceTime audio chats, incoming and outgoing. The storage for that is actually 200 records. So you can only store up to 200 of each. Now, if you were a user of, let's say, WhatsApp or Signal or Telegram, those would each count too, and they'd get their own logs. So when we look at the database for the number of calls between 8:59 a.m. or 8:57, again, I apologize, I'm not looking at that precise time, on the 29th of January in 2022, there are exactly 200 calls still in that record from then until the imaging of the phone. There are 199 FaceTime video calls and only 27 FaceTime audio calls. So the question is, how do you validate that that's what's happening? So we actually have call logs that we can pick up in other places for recent call logs in the last 7 to 30 days, depending on the exact version of the device and how the biomes are running. We can actually see incoming call logs, the number they go to, and if they're incoming or outgoing in the biomes. So we actually can see the history going back for the entirety of that day on January 29th till midnight. Again, my scope was from midnight until noon. So we can actually see all of the calls. They're just not all call history state DB. Now, the call history state DB, from a user perspective, that button on your phone doesn't say call history. It actually says recents. And what it's determining as recents is the most recent 200 of each category. Now, how did I determine this further? There is a running log that exists in a phone. It lasts about 3 days. It's called the unified log. The unified log tracks multiple things that are happening on the phone. In manual analysis of the unified log from this phone, I can clearly see each time a 201st call comes in, the 200th call gets deleted. So it's constantly just the last 200 calls. It may not be typical that we see 200 calls in 3 days, But on this device, we do see 200 regular phone calls in the 3 days between 8:59 a.m. on the 29th and when the phone was imaged.
Do you have an opinion to a reasonable degree of scientific certainty whether there was any user deletions from the phone call log that morning?
Yes.
And what is that opinion?
The opinion is that I can see that it's done by the device itself utilizing unified logs, that the system is deleting the 201st call every time a new call is received or outgoing.
Thank you. I have no further questions.
All right, can I see counsel at Sidebar regarding scheduling and a few things?
Oh, that's sidebar number 9. We've got like 10 minutes. I don't think we're going to make it to 11 before lunch. Whoa. Well, from what I can see from some of the reporters that are inside the courtroom, they're saying that a lot of that not only is Alan Jackson taking furious notes for these, that the jurors themselves were taking notes, but some of them looked a little confused when she started talking about the food in the restaurant. They did not make as big a reaction as you would expect to her statement about what time the actual search happened. There was no like looking at her direct or picking up their heads. They're just writing notes. There's one juror particular that's been pretty stone-faced during the whole process, and several people have noted they're making no expression at all. And that particular juror is paying extreme attention to everything that this expert witness is saying. They're also making note that she's been allowed to talk for like 3 or 4 minutes straight. That can lose a jury if it gets to be a little too long-winded. They start to wonder what exactly it is you're saying. I realize that the prosecution, the Commonwealth, wants to make it as simple for the jury as possible and give the best explanation so they can understand it in different terms. But it's a risk to let it carry on so long. That was number 9, I believe, Rocky Couch, number 9 sidebar. But this one, she called for scheduling. She told the defense straight out with sidebar number 8 that it was the last time they could sidebar on this particular issue. She'd had it. Like she done. Like that's it. And apparently, according to those in the courtroom, they can't hear exactly what was being said, but they did say it was between Alessi and the judge, and that Alessi was quite animated and very passionate and was pointing his
All
pen.
right, Ms. Hyde, I'm gonna let the jurors have lunch. You can walk out after.
Thank you. Thank you, Your Honor.
All right, we're breaking for lunch.
Thank you, Your
Jurors
Honor.
will recess for 45 minutes for lunch.
All rise for the court, please. Here's your notebooks. Follow me.
Okay, so if we're breaking for a 45-minute lunch, that brings us back at about 1:30. This is the link to the next stream. I break this up into 2 streams a day to make YouTube a little happier. I hate seeing 6 and 8 hour streams on my feed. It makes me crazy. Who could sit through all of that? And plus, it gives us all the time to take a break, take a walk, get some air, get something to drink, something to eat, just refresh ourselves, keep us from banging our heads on the desk, or getting brain mush with the length of time. Oh, we have a new light. Look at the metal spotlights over there next to the plug. That's a new look. I don't believe we've seen this view. Dangle Dome is getting like front and center. Well, on that, I'm going to break for lunch. I'm just giving her a minute to see if she comes back after the jury leaves, because sometimes she does that to say something to the attorneys. So I'm just going to wait another minute or 2 to make sure she doesn't catch me off guard. I do want to thank those of you that came last night to the True Crime and Legal Updates. First one I've done in a couple of weeks. It's hard to sometimes get that on schedule on a Tuesday night with the trials going, depending on if they go long or what kind of a stupor they've put me in by the end of the day. But I did enjoy it last night. We talked about Lori Vallow, Daybell, and Sean Combs, P. Diddy, who's going through jury selection. It just quick up through, and Lori Valadebel going for a retrial for juror misconduct, which I do believe that's going to go through, actually. Ongoing training, teaching, and research. I get it. Like, she looks good. You know, she's a little long-winded, but that's an excellent witness. You know, I mean, she's an expert. Oh, they're very upset about her not being able to discredit her. I think they thought they had the biggest gotcha with that court case, even though it wasn't exactly. It was her testimony that got daubered out. But however, it wasn't about the same thing, so it has to be relevant. Because let's be honest, Richard Green, their expert with, like, here's the hypocrisy for me, okay? Just in case you guys all forgot, we went through hearings in the beginning of, before this actually came to trial, and their expert witness on this particular issue was precisely on when was that search done, that search done. 227 or 604, whatever the second time is, don't quote me, it's around there. That expert witness has actually faced perjury charges for his testimony and has a record in misleading the court. I do believe it was for misleading the court. I'll have to double check, but he has a record. And that actually was a hearing on whether or not to let that in. And of course, they're not going to let it in because it doesn't have anything to do with the search that he's doing now. It wasn't the same kind of evidence or anything like that. And so that didn't get allowed. So the nerve, you know, I mean, you know, really. I just find it ironic. But I was surprised to hear Alessi say, we're not sure we're going to be presenting Mr. Green as an expert witness. He's on the list, but they don't have to bring him in. Yes, he does, doesn't he, Liam? Yeah. It seems to me that, you know, you get a step up if you're willing to cross the lines to join that team. I mean, we're just drawing lines here, just all of them, including the ARCA witnesses who were presented as being completely neutral, but were paid. It just didn't bother to say anything to anybody. And if it wasn't a problem, then why wasn't it disclosed by Alec Jackson when directly asked by the judge in February? I mean, he paid it last July. I mean, why not just disclose it? Because it looks better that they're neutral. Because it looked real good for them that they were neutral and they were going against the Commonwealth's theory. They were like, look at these outsiders who have nothing to do with the case come in and they agree with us. Yay. But that ain't the case. Now it's, look at these expert witnesses who have testified elsewhere, but we're paying them to come in here and testify to our case. Perfectly legal, perfectly standard. There was no need to lie about it, except for they wanted it to look better than it was. They wanted to twist the narrative. And by doing that, they made themselves look really bad. Really, really bad. Charges of lack of candor to the court, sanctions, allegations of sanctions that may come forth, an admonishment on the record from the judge in this case. I still think something's going to happen after the trial is over. I do believe inquiries into the regulating organizations would be appropriate. Being willing to use a communication tool that automatically cleans up its own evidence did seem to work out for ARCA. Yeah, it did, didn't it? Didn't it? Oh, by the way, a communication device they never used before that the defense directly asked them to use for communications. But hey, I digress. I mean, that don't look sus at all, right? Nah. Don't look like a problem. No. All right. Doesn't look like she's coming back. I'm breaking for lunch. I will see you all in 30 minutes or so. Stream link is right there. I did post it. Yeah. Let me just post it again just in case. so that it's the last thing at the bottom. No, on both. I will see you all in a little bit. Take a stretch, take a break, take a drink, get some fresh air, and I hope that you will keep me company this afternoon. See you in a bit.